May it please your lordship. With the consent of other side, I beg to mention item number 13, lordship.
13.
13, lordship. So matter may be come up in the next week, lordship. I have some inconvenience today.
My lord, if possible on 27th, my lord. 27th.
Will it be possible?
It will not take up, my lord, too long, my lord. That matter is not very complicated. It will not take long.
Anyway. I think 29 will
29. 29.
Deep level.
Stop it.
Interim order is there.
Interim order. Interim order.
Oblige.
Deep level.
May I please, your lordship. With the consent of the council for the informant, my lord, I beg to mention item number 23. We're making the payment, my lord, in this matter. Because of some complications, 2 weeks may be granted, my lord.
Lordship granted the interim bail on the subject that one agreement was signed between the parties, Lordship, and 16th was the last date of compliance of the terms of the said agreement. But today they are seeking adjournment on personal difficulty. I am not objecting.
Because of
But
this
on
election,
last
my
day,
lord.
on next date, Lordship, they may file one affidavit informing your Lordship the status of compliance of the agreement. That much.
As per you, what is the compliance now? They have complied any in person to the order. I don't know.
Around 70% of the payment has been already.
That status only they can bring by filing an affidavit.
On the next day, we will file that.
23.
There are council for the however dedicated to face the compliance form of. Next date you want how many?
2 weeks, my lord, first week of June. Date may be fixed.
At a side rate, first rate, third rate,
6.
So by the bail order, this the payment is continuing.
One agreement signed between the parties, Lordship, and there, so far as my instruction is concerned, they have complied some terms, but not all the terms, Lordship. That is why they are praying for adjournment. So let them come on the next date, Lordship.
And whether any case diary, etc., was called for on the earlier occasion?
Updated case diary, as per the last order, updated
Initially,
case
the
diary
bail was
called for.
rejected. Initially, the bail was rejected. 2 days after Lordship, this agreement was signed, and your Lordship was pleased to grant them the interim bail. That is the situation. Otherwise, bail was granted. I mean, rejected.
This is BA, my lord. नाम तो लिखिए आइटम नंबर
Okay. That was the case. Huh? So
On 6th, Lordship.
6. Okay.
They will come. They will file one status report.
Yes, I have already got.
Obliged, Lord.
deeply.
May I please, Lordship? I beg to mention item number 22.
20?
22. And let me kindly adjourn for it.
22.
Yes, ma'am. Matter may be adjourned for a week.
Just charge it at one.
Yes.
So better to dispose the matter because otherwise it will be just pending and if it is disposed of, you may get a chance
out of
to
station today.
Out of station, and I have
He is legs on Karimganj.
no, but from where you are sitting, it is a charge sheeted matter otherwise. Okay. The request matter so this matter. So
next day.
For a week.
for
Next week.
was an emotion. After one 10 days. So,
Lordship, I beg to mention item number 16. Due to some difficulties, Senior Counsel S. Bhottakur is not present. Kindly matter may be again next week. Item number 16, Lordship.
So have you informed the respondents that the two names are there for the private respondents? Names are there, but
Content has been not taken.
not taken, it's just informed. You are Mr.
S.J. Sohoria.
S.J. Sohoria,
Lordship, earlier interim may be continued.
and
तेरे inform तो कोई ठीक होना होता है
it's recording. It's recording after one, after hasn't
Lordship, earlier interim may be continued.
yes, I have a problem.
May I please your lordship? I beg to mention item number 4. My senior has some personal difficulties today, so kindly take the matter in the next week.
You know, Mr. Tibusha.
Yes.
List. List the matter recording. No? After 2 weeks. Just after 2 weeks.
May I please your lordship? I beg to mention AB 1233/24. As per instruction of the petitioner, we want to withdraw. Item number
और listing
AB 1233/24, your lordship.
You want to withdraw?
Yes, your lordship. Okay.
mention
You will get a
May I have his lordship? Lordship, I beg to mention for listing one criminal petition, lordship, for quashing. Lordship, this week, any date, lordship, possible?
This week to know that.
And this week, before Friday. Because lordship,
Friday,
on 29,
of,
this matter is fixed, has been fixed. This matter is fixed for on 29, lordship, before lower courts. Before 29, and then.
Because 23rd, 25th, 26th are all our holidays.
So, lordship, before 29, any date, lordship.
Before 29. Before 29, can it be any day? I think it's there. Before 29, it is not available. June. 27 is a Monday? Okay, then 28. 27.
27. Much obliged, lordship.
Which item you say? Listing.
Listing.
Your Lordship, in item number 25, which has been fixed today, one senior from the Supreme Court will be appearing through VC. So I have sent the requisition as per the format prescribed. So if your Lordship will direct the courtmaster to provide me the link so that the senior may join, because they are waiting. It was sent yesterday. I think it got delivered today.
One thing, for as per your confidence, we're going to fix a date for listing. Today, most probably it may not be possible. So make it on today's Monday, maybe on 24th. 20 will not be possible.
Today not be possible.
No. So either tomorrow or Wednesday. 24th can be.
24.
24th, yes.
This month 24.
Yes, this one.
Yes. Then we'll be highly obliged. In the meanwhile, Your Honor may just extend the interim.
Interim was there?
Yeah, interim was there. In fact, it is a very long pending matter.
Okay. Yes, 2019. It's of 2019 matter.
Yes.
No. 24.
And the trial is also pending from 2013.
Oh. Interim because it's still listed. Okay, we're listing it on 24th. We'll try to provide you the link. Okay.
Obliged.
May it please the Lordship, I have instructions to withdraw this matter. It's been settled between the parties.
You are the other side?
Yeah, that's good.
Hardness, either, not and also submitted by that's by instruction of the bank as the method was selected. The matter be according to why it has come for me before the big bill was not
Maybe
same connection. Was there any other bill from the same connection? Because actually I don't know why it has been said.
Why that application has come before your lordship?
Yes, yes,
Huh, this is not a rejected application also.
yes. Why it
My
has
lord,
come?
I am the secretary,
No, you
petitioner.
may be secretary. Why it has come?
My lord, on the other days, my lord, president already enlarged on bail by this court, my lord.
Oh,
Question.
then was there. So
Yes,
now
my
you are
lord.
secretary.
Yes, my lord.
Co-accused.
Lordship, yes, the bill of my lord.
Gafur Chandra Das, lordship has passed the order.
Yes.
My lord, Perry the Crown, my lord. I am the secretary, my lord. I am arrested along with the president on my lord. 16/4/24, my lord. Today, my lord, already 37 days, no? 34 days, my lord.
He is Liton Das. Allegations are actually against Taposh Das.
One Taposh Das.
Taposh Das. But then the president and the secretary of Puja are allowing gambling. He is the secretary. Now he is the secretary here.
That is the allegation against you. Most probably they allowed the gambling indeed. Though they was not there, but that's yeah.
Only this statement.
Okay, then in that case, if it is he is the president and this one is the secretary, so parity may be there. I think.
President lordship has allowed.
To order of the cow paper. So your date of birth is
My lord, 16/4/24, my lord.
16/4.
President is also 16/4 only.
16/4.
Same date, my lord, along with.
You're giving me this one? I'll keep it.
Just first, second paragraph, after here you petitioner Mr. Puri for the about go ahead. Also considering the round of very as it is a completed for the phase. High order 10/5. Okay.
I am obliged, my lord.
Obliged.
Yeah, record it.
A to P answer.
Sessions of Friday. May it please your lordships.
Yes.
Lordships, this bail petition has been filed in a case which is pending before the additional session judge number 2 at Kamrup Metro Lordship. The
Now,
case
why it has come up
why?
before your lordship that
for bail
not for bail, but what is the reason?
for
Why it
reason
has come up?
lordship for last 14 months he is under custody lordship.
No, we are not on that. Why this bail petition is before this court?
Before this court, because on earlier occasion most probably this honorable court has rejected this petition, his petition lordship. That is at page 37.
Okay,
This may be the reason.
Okay.
On 22/2/2024,
Yes.
Your Lordship was pleased to reject this the bail application of this petitioner Lordship, and he has approached this honorable court after 3 months. Lordship, in this case, Lordship, there are as many as 21 witnesses are to be examined, out of whom only 5 witnesses could have been examined from the month of December till May. Most of the witnesses are official witnesses because the case totally rests on circumstantial evidence.
It's a very serious kind of election.
Murder is there. I mean, he was
Murder
killed.
is there. There is
302.
392 is there. Lordship, I am not on the sections, Lordship. I am submitting before your Lordship that the trial may go long, Lordship. And the petitioner is...
Can you tell us what is this present status? Because
present status, Lordship, already 5 PWs have been examined, including the informant and 4 independent witnesses out of... and these witnesses, I have annexed, Lordship, from page number 18 onwards. The evidences of these witnesses have been annexed, Lordship. And in their evidence, there is nothing against the present petitioner, Lordship.
We don't have any status. We don't have any.
Moreover, circumstantial evidence, it will have to be again seen.
No, he
Yes.
is on
I have the
that
certified
on
copy
the
of this
day
Lordship.
of when we passed the order on 22nd. I don't know at this stage
yes,
what the number of witnesses do they examine, but now he is stating that 5 numbers of
Yes,
witnesses.
5 examined.
In that order, Lordship will see
Yes.
3 numbers were examined.
Now it
3
is-
were examined at the time.
So it's a, I mean,
And all are official witnesses, Caesar witness, and thereafter the forensic doctor, PM, etc. These are the witnesses, Lordship. There is no eyewitness. From the record, it may come up that there is no eyewitness. The occurrence took place in the month of April 2022, and the accused persons, 4 or 5 accused persons, were apprehended in the month of February, Lordship, 2023.
Can we call for the present status?
The case status.
Lordship, that can be called for on 29/5. The case is fixed before the trial court, Lordship. On 29/5. 5, Lordship.
So in 29/5, the probability of examining more witnesses
More
may be
witnesses.
there. So
Let the case record come. We will see whether any allegation is against him.
Can it be on 29 or 28? One day prior may be there, or if it is after 29, then it will be most.
Yes, Lordship. After 29 will be better,
Will be
Lordship.
better.
After 29.
Lordship.
Today is
After
28.
29, and it is 30, 31.
31.
5. We are calling.
Obliged, Lordship.
Also the scan copy of the it's not 35. Okay, 31.5. Okay, we are listing on 35.
No.
31.5.
Obliged.
May I please, Your Lordship? The prisoner before Lordship, my Lord, is a notary public, my Lord, of Barpeta Court, my Lord. What has happened? He has submitted one in a case under 125 proceeding, my Lord. There was a direction of this honorable court, my Lord, while disposing of a revision petition to submit assets and liability statement. Because there is a Supreme Court decision, Neha. And that in pursuance of that, or court directed the both the parties to submit assets and liability. Now, what happens over the first party is concerned? He has filed the affidavit was filed without the signature or a deponent.
With the signature of the advocate.
Yes, without the signature of the deponent, my Lord. The first party, it was filed. Now, the court actually ought not have been taken into consideration because the office should not have taken it because deponent signature is not there, man. But I don't know if I understand the office has to have to file it. Also, it was placed before the court. The court took it otherwise. Court says that how without a signature of deponent case filed, it fall upon the deponent. And deponent says some statements are not there, correct. So I did not put the signature. So matter is there. Now the court has taken a cognizance against the inquiry under section 340 and two cognizance against these petitioner under section 194, 197, 465, 467, 468. My humble submission before your Lordship, before coming to the, because that document is not a affidavit, has not been signed. So it is not evidence as such. Your Honor, Lordship may kindly see. If had the deponent had signed it, that matter actually it would not have been processed. So I have put my notary signature without the signature of the deponent. I understand. That means I have violated rules of the Notary Act. There is specific provision laid down on the Notary Act. If I violate. But so far as IPC offense are concerned regarding document, where is the forgery? I have not forged any document. The signature has not, deponent has not. It ought not to have been processed here. Your Lordship, I'm taking up your Lordship.
But being a notary magistrate,
Yes.
without the deponent, you have.
Yes, that I have given explanation because of good faith. It was done because lawyer said I will put the signature later on. That it was some sort of understanding, but whatever it is, but it is a fact, my lord. Now,
What is going on in every.
now there is another important aspect in this case, your lord. The Notary Act, my lord. That your lordship may kindly come to Notary Act, my lord. That is, I am giving a copy to your lordship. That because I am governed by this Notary Act 1952. It is still is in force, my lord, and the rules has been framed also. Your lordship may kindly come to page section 13, my lord. Page 6. No court shall take cognizance of any offence committed by a notary in exercise of purported exercise of his functions under this act, save upon a complaint in writing made by officer authorized by central government or state government by general or special authority. So there is a specific bar, my lord, laid down under the act. Because if I have committed any offence while exercising power as a notary, then there has to be a complaint. Complaint has to come from the officer authorized by the central government or the state government. Means the appointing authority has to file a complaint. Then only cognizance can be taken. At best, the family court judge ought to have written to the state government, to my appointing authority, about the whatever illegalities or whatever infirmities I have committed. But instead of that, he has taken cognizance under section 464, 468, 194, 192. So my first commission, because that document itself is not admissible, that affidavit. So it is not a piece of evidence as such under section 3 of the Evidence Act. The signature of the deponent is messy. Your Lord, I'm taking you to your lordship with the order, madam. It's a very cryptic order, your lordship. That is starts from page 13. Page 13, 1-3, madam. It is order dated 4/11/2013 to 4/11/2023, madam. There, your lordship, right? The petition has second para. Petitioner has submitted a format of affidavit purporting to be an affidavit of disclosure of assets and liability, stating that her advocate presented the said document before her, asked for her to put her signature. Said format of affidavit corresponds to court P number so and so, and it kept in the case record after being initialed by me. The petitioner says the affidavit contains some false statements and there is concerned advocate pressurizing her to put her signature. Said document runs into 13 pages. Each pages contain the round seal of the notary public Ajit Kumar Sarkar, that is present petitioner, to registration number so and so. Each of the pages contains seal and notary with his signature and so on to have been corresponding serial number so and so. And the signature contains the signature of the advocate, and the advocate has identified their opponent, except the last page, the name so and so. On the page 13, name of the identifying so and so. Petitioner says what is written is so and so. She has described her grievance is that there it is stated that she is received a total amount of rupees 12,30,000 as area, which is not a correct statement. It is regarding the sum, my lord. That is that's why she did not put her signature. They said already we solved the case number. Insert case was written on the first page. So and so, issue notice so and so, and that so-called notice was issued, my lord. Then your lordship come to the next page, my lord. Then inquiry was conducted, my lord. That after conducting the inquiry, my lord, he has recorded the statement of some witnesses also, your lordship. Then thereafter, that your lordship will kindly come to page 37, my lord. 37, my lord. That is the order which is under challenge. The said order is pursuant to an inquiry under section CRPC, which is genesis of the order dated 4/11/2000 passed in this case. Order says that facts and events leading to this court does not consider necessary to delineate them and again. Suffice to say, on a verbal complaint by the petitioner in this case, this advocate prepared his affidavit purporting to be her assets and liability without consulting her adequately by making some incorrect and false statement therein, had submitted a purported affidavit which doesn't contain her signature any of the pages.
It was noticed that the affidavit contains the signature of advocate so and so, purporting identifying signature of fictitious deponent, whose signature doesn't appear on the affidavit. Nevertheless, said affidavit purported to have been prepared on the behalf of petitioner Timothy so and so. It was seen that the said affidavit has been notarized by the notary public so and so. Clearly said notary could not have notarized the affidavit as he was supposed to administer oath to the deponent and only to authenticate the same, where the document expressly shows that present petitioner was not appeared before him. It is also created a false impression on the oath was duly administered to deponent. This is a strong presumption of conscious active knowledge of so and so, actuated by case number and written on it, and the court started showing that it was to be presented before the said court. It could be presented before the court, could be used as a piece of evidence for the purpose of judicial determination of the questions issued before the court. In view of above, notary public so and so served with notices requiring them to explain why appropriate legal proceedings shall not be issued against them. On the basis of the explanation by the said notary public, finding of the advocate so and so is vital, useful witnesses. The court has perused the oath statement of notary so and so. His statement says that he has discussed everything, my lord, that regarding the explanation given by us, my lord. Then thereafter, my lord, and the statement of the advocate was also taken into consideration, and the finding, your lordship will find kindly. That paragraph 7, my lord. Therefore, that indicates that notary public Sarkar as a primary premise is guilty of committing an offence so and so of the liable to prosecute and similarly offenses so and so. So, now first of all, the affidavit has not been signed by the deponent. It not to have been placed before the court. The deponent has not signed. Deponent has not signed it because it ought not have been processed, man, with a signature. He has disputed because of the area salary. The area maintenance, he says that amount doesn't tell you with that. So, there is no evidence as such. The court finding that may be used as evidence. So, where is the evidence? If evidence of any character, evidence of affidavit means there is no signature. Without the signature, it cannot be treated as an evidence in affidavit. This is my first submission. And there is no forgery as such. Where is the forgery I have committed here? And neither there is alteration of any document, neither signature of any deponent has been forged. Nothing has been forged. Now, so far as the act is very specific here, because I have to give an oath under the act, and if there is malpractices on my part, my lord, then there is then I can be removed from the office of the notary, my lord, and therefore that purpose there has to be inquiry committed by the competent authority. And in fact, that for that purpose, this specific provision has been laid down that under section 13, that no court shall take cognizance of any offence committed by a notary in exercise of or purported exercise of his functions under this act, save upon a complaint. So now, since I have exercised the power under the Notary Act, so naturally, even if I have committed any offence under IPC, whatever section, then this section 13 comes into play. And in view of the specific bar laid down under section 13 here, there is a decision of Supreme Court, there is Bhajanlal case, as your lordship is aware, that if there is a specific bar, the proceeding cannot be initiated. The proceeding cannot be initiated and is liable to be quashed, because there is a specific bar. So, in view of that, in view of these provisions, my lord, my humble submission, at least as notice may be issued, my lord, and proceeding may be stayed.
As far as 340 is concerned, what I see is the proceeding was continuing before the court, and in between this affidavit had come. So it was done during the course of the proceeding. And since the deponent is not agreeable with the affidavit, and this is what my learned friend said, and so he did not sign. And then a notary public putting his signature, it amounts to giving not forgery, but giving a false evidence, false statement, false submissions. It amounted to offences under section 173, 4,
no.
False statement, 182. So, not forgery, he has not forged anything. But then,
cognizance has taken under forgery here.
No, these other sections are also there.
194, that is also regarding
false statement.
False evidence.
False evidence.
That is not treated as evidence also. How can we treat it without signature of deponent?
But then he had passed. He is the last.
May not be treated that it was produced before the
pending proceeding. So 340 complaint, independent complaint under a notary is a separate thing, and this 340 is a is a proper procedure. Let us see in details what we. At the meantime, Lordship will issue notice.
Yes.
Stay like it.
Because they have laid down procedure rules also very clear, my lord, regarding notary public rules, my lord. How to go
But
against
if we see the ground reality, it happens sometimes without taking signatures on affidavit.
Well, it ought not
Notary
to be
public
processed,
signs. If I go with an affidavit of my family member, they will definitely sign, even if my family member has not. So ground reality, it happens sometimes.
And now the question is that office would not have taken into consideration without a signature. They should not have processed. That is the thing.
Why is it?
Rejected.
But every page there has to be a signature.
Also rejected right out without a signature.
And it's not one signature. The opponent has to sign in every page. That was also not noticed. Right?
No problem. That yes, the fact that without being signed by phone, but that cannot be considered as a
fitting distance
evidence for the court or false evidence for the court.
High Court.
Not taken
in the High Court.
একটু উপরে যাব লাগবে কন্ট্রাক্টে কোন একটু
সেইটোতো হ'বই আগতে প্ৰিফাৰটো হ'ব যদি হয়
পাৰাত আহি যাব কমপ্লেইন
but notwithstanding non-objection clause
নাই নো কোড বুলি কৈছে ন
no court will take cognizance.
আনিলে বেলেগ কথা পৃথিবী পাৰে
It's a special statute. If they have to see, they will overdo that.
But
no court will take cognizance of the
this has been registered as case number. What is case
the CR case number you will also find at
page 37.
CR 225
yes ma'am
pending before which court?
is CGM Borbeta ma'am
CR
225 2024
pending before this recording. Okay, it will state after 3 weeks. We are calling for this scan copy also.
Yes.
Otherwise, the orders are here only.
yes
If it doesn't reach also, it can be heard.
yes.
Chief.
নতুন চশমা পার্টি বলে গেছে নতুন চশমা কিনা পার্টি বলে গেছে
কি হয় এইটো
কোশ্চেন
FIR
কিডি লক জানা কিডি লক কিডি লক
বাচ্চার লক
Maybe complete by 4 central government or state government.
Complaint case
Against any transaction of
কোয়ালি কোলালে মাই দুর্গা
Abdul Hai and another Abdul Hai
মা দুর্গা কোলালে মামা হতো ভাইকে
Ruhul Amin
চিনিব নাকি item 6 right?
yes, item 6.
Mail lordship. This is also an application for quashing of the proceeding, my lord, under PRC case number 849/2023, pending before the CGM Nagaon.
but charge sheet also is being challenged. Here, what means this is a case of what is commonly said as kiddie law, my lord. Kiddie law, law between two kids. Both are minor, below 18 years, and a boy is below even 17 years, 70 years something. And girl is 1 month, 25 days elder to the boy. Both eloped at the night of 2 a.m., dead night of 2 a.m. from the house. The FIR is marked at page 11. Kindly come to page 11. 6, no?
Okay, yes.
FIR is at page 11, my lord. Incident is of 17/7/2022, and it was the FIR was filed on 1/8/2022. To the officials of Batadara Police Station, Ezhar, Abdul Majid, father of the girl, and this Khairul Islam is the minor, the boy who fled with the girl, the minor girl, and Rubal Amin, an unknown person. All are resident. Most respectfully state that I, Muhammad Abdul Majid, a permanent resident of Salapathar, under the Batadara Police Station, on 17/7/2022 at about 2 a.m. at night. Kindly note the time, my lord. Taking advantage of my absence at home, the above named accused number 1, that is the minor boy, Khairul, along with one unknown person only, have kidnapped my daughter Muhammad Marjina Begum, 76 months. In the morning, not finding my daughter in her room, and on inquiry, I came to know that that my daughter eloped with the above named Khairul, accused number 1, that is Khairul Islam. Then my nephew Jarul Islam went to the house of the accused persons and discussed the matter with the accused number 3. Since my daughter is minor, therefore we decided to, once she turns major, 18, we will get them married socially and even executed an agreement in the court on it. Sir, the incident is not ended yet. Again, the accused number 1, with the help of the accused number 2 and 3 and 4, taken away my daughter, and due to fear, they confined secretly my daughter in the house of the grandmother of accused number 1. Thereafter, the accused number 1 had even been avoiding to meet my daughter on another pretext, for which my daughter left the house of the grandmother of the accused number 1 for his house. Then the above named accused persons abused my daughter with filthy language because she was chided, my lord. She was abused by the parents. The number 2 and 3 have also chased me down. After that, our fear of my daughter looked herself inside the house and informed me about the incident over the phone. Sir, we tried to sit together and settle the matter, but failed to do so, since we are trying to settle the matter amicably, for which caused delay in finalizing the matter. And thereafter, my lord, there is agreement between the parties, my lord. That is Annexure C. In 164, my lord, there is not legible. However, some person who translated, the girl admits that they were in love. Agreement C, my lord, page 21. Okay. Page 21, has also got, man. Deed of declaration. First party, Abdul Hai, son of so-and-so, the petitioner 1. The second one, Abdul Majid, the father of the girl, that's so-and-so. Both parties are entered into a contract after mutual consent of the following terms and conditions on this 21st May, July 2022. That the first party is elder brother of Khairul Islam. There is girl's daughter birth is 5/2/2005, and the second party is the father of Marjina Begum, who is date of birth is 12/12/2004. There is 1 month 25 days. The boy was younger to the girl. Both the parties guardian desired to solemnize the marriage of their brothers and daughters, but due to minor condition, they have failed to do so. that both the parties entered into a contract that when their above mentioned children will complete their age, then both parties will be solemnized of their marriage. That if the aforesaid boy will marry another girl, then his brother, the first party, will be given 1,50,000 rupees only to the second party. And
So
if
have you
the
placed this deed of declaration or deed of compromise, whatever, before the IO?
no, this will be
Deed of
before the notary.
compromise is showing to be executed on 21st of July
Yes,
2022.
yes.
And as per the thing, the charge sheet was filed on 31st of December 2022.
Yes.
So have you placed this thing before the IO?
My lord?
Before IO, have you placed the affidavit?
This
or
one?
deed of declaration? What?
This agreement.
Yes, agreement.
Agreement, my lord, they might have, I don't have instruction as such, but charge sheet was filed, my lord. And here, my lord, it is a case, and the girl, whatever, my lord, in the meantime, she fled away with another boy. Paragraph 11, you'll also kindly count paragraph 11.
Paragraph 11 of which?
My petition.
She fled with another boy.
And ultimately, the parents were forced to get them married amicably. Paragraph 11. There the petition begs to say that while there was an agreement executed between the guardians of both the sides, yet the girl, in spite of the agreement, went away and married a different man, namely one Mujibur Rahman, son of Muhammad Asmat Ali of village Amraguri, P.S. Lavrigat, district Marigaon. Soon after, she stepped into the age of majority. Soon after 6 months, she entered into age 18 years. Now she is 8 months pregnant. So, my lord, in this way of the matter, she has married and went away. And my lord, she is the only witness in the incident. Because she, actually, both, whatever Mali incident was, she was sleeping with her parents. The boy calls, I am coming to pick you up. She opens the door and runs away at night. They elope. You also know kitty love. And the boy had to be in the juvenile home now. And the girl comfortably got married, another man and married. She was very in a hurry to marry. It is a very interesting case, my lord. You should notice, and interim order may be given.
In fact, relationship was there at his writ large, and exaggerations, perhaps threatening, raping, and against these two persons, Abdul Hai and Lee. These are the brothers of the main accused. I think main accused is not before your lordship, but Abdul Hai and
juvenile home.
Oh, achha, he's in juvenile. Abdul Hai and Ruhul Amin, only one statement that I get in her 164 statement that they have raped me.
No, accused number 1. Accused number 1.
No, where I've just got it. Wait, lordship will see 164 statement of that girl.
Page 20.
Page 15. I mean the translated part.
Yes.
Page 15. Lordship will see page 16. Only this statement, when Khairul took me to his uncle's house. Khairul is the boy?
Boy.
Uncle's house. The uncle Ruhul Amin and Abdul Hai, brother of Khairul, have forcefully raped me. These two are the petitioners before your lordship. So only this statement. And
But
this seems to be perhaps exaggerated because
exaggeration.
apart from that, there are so many exaggerated statements.
Yes.
Let the records come. We'll see the statement of other witnesses if they have stated something. Otherwise, this boy should not suffer for these
Girl is
faults.
not settled.
Oh, boy is
Girl is not settled well.
No, boy should also not suffer. And these two uncle.
The both are never. Just about a furlong away they live.
Otherwise, in the FIR or in the main part of the 164, no allegations against these two persons. Only the last line.
Yes. It is exaggerated. It was an afterthought also.
And now, after charge-sheeted cases that posted, whether
Just charges
appearance.
No, not evidence. Just
No, appearance.
Preliminary stage. This is by Ankita Deka. Notun pinsan yung dahil pati ko lang. Notun pinsan isa po. Non-berit bola. Mere bola.
Yes, sir. There was an option for that. But each sitting of year
No, it is non-berit bola.
49.
Break no.
Pending for determined CPM now come. Each state is 40. Also call for
He is a law to enable positive.
We are calling scan copy of the LCS. He is there.
Yes.
And it will be listed after 3. Till then, this first thing. Take issue notice also to the respondent number 2.
Yes. Yes. Not your words was granted interim order, my lord.
Yes, take.
Obviously.
Bail doesn't I get Bail doesn't
No.
May I please, Lordships? This is for my lord. The washing and setting aside the charge sheet, my lord. Charge sheet is 8 page, my lord, page 16, my lord. But unfortunately, my lord, translated type copy could not be submitted, my lord. Yes, sir. My lord, I may be allowed to submit the translated type copy, my lord. And in the meantime, you lost, my lord.
It's not properly legible also.
Yes, my lord. But unfortunately, I will file, my lord.
You can file by
So
way of
that-
an additional affidavit.
Yes, by way of additional affidavit, and that may be being into a record, my lord. Thereafter, case may be listed. My lord. I will file it tomorrow, my lord.
Heart Mr.
Yes, Ahmed.
Abi, not the heart. That type of the chart to not file. And the copy which has been was not proper designated. And he wants to file a type copy that's the copy of the chart. It be of prayer the petitioner is asked to file a petition. Letter will be listed accordingly after file.
My lord, kindly date may be fixed, my lord. Tomorrow I will file, my lord, and matter may be listed on.
Will not come.
Not tomorrow, my lord. Listed on, my lord, 28th if possible, my lord. Otherwise, my lord, that case is pending, my lord. The appearance there. That's why on 28th, my lord.
29.
29. Oblige, my lord. Much obliged.
List accordingly.
Oblige, my lord.
May I please, Lordship? Lordship, the petition of file, my lord, against my lord, order item, my lord, 6/4/2024, my lord, annex of 4, my lord. Page number 35. Page 35, my lord.
35.
35, my lord. Whereby, my lord, the petitioner declared as proclaimed offender, my lord. My lord, section 82 of 82 CRPC, my lord. Post 4, my lord. May I read, my lord?
So after several attempts being made, thereafter only the court has to declare him as an absconder.
Next one, my lord.
Not
My lord,
the earlier orders you have not annexed.
my lord, earlier bail obtained, my lord.
No. Earlier orders.
Earlier orders, my lord.
Because there is nothing in the record. You did not annex. You have not annexed any order sheet. Since when he was in showing absconder whether summons were issued or not, that has to be changed. So it's not here.
My lord, issue NBW, my lord, on 30/10/2023,
Whatever.
my
They
lord.
have not annexed the order.
My lord, my lord.
Annex the order, otherwise it would be.
Annex
the order should be listed after 1 week. You annex by the time you annex all the order.
Gotcha.
Because otherwise it could have been booked off today itself, but it's not here. No order.
My lord.
We have to at least minimum see the conduct of the
May I please your lordship?
Yes.
Lordship, this is earlier rejected case. Lordship may kindly peruse FIR first at page number 13. Here, Lordship, allegation is that a truck was hijacked with 425 bags of Assam dried areca nuts. I think Lordship has gone several times this
several
FIR.
times I have gone.
And now Lordship may kindly peruse
So
the page number.
here your petitioner is for anticipated.
Anticipated bill, Atwar Rahman and Lordship Zainal Abdin. Here, Lordship may kindly peruse page number 15. Ground of the arrest. Here, 3 persons have been arrested, and later, these 2 persons, Abdul Hussain and Somar Ali, they were also released. I have annexed all the documents. Here, Lordship,
Separate thing. You're seeking a 3 years bail. Yeah?
yes, bill, Lordship. What happened,
It was
Lordship?
rejected.
Earlier rejected, Lordship.
Okay.
We were, Lordship, only part involved in case of our case. We loaded, unloaded in Kharupetia district. We do this type of things, Lordship. In this case, Lordship, ground of arrest, page number 15, direct allegation is saying that during investigation, it is learned that Ali Hussain and Islam Khan, along with the below noted accused persons hijacking the truck number so and so, here 3 names involved. Ali Hussain, Islam Khan, and arrested persons, that is Abdul Hussain, Somar Ali. And now, Lordship may kindly peruse page number 26. 26. The Ali Hussain. He got interim protection, Lordship. So, Lordship, in that line, we may also be protected, Lordship. We will appear at any condition, Lordship. If anything found against us, Lordship, our bail may be rejected. Only 1 chance may kindly be given, Lordship. I am praying, Lordship, because we are only doing these things, loading and unloading. 1 chance may kindly be given, Lordship. Because these persons are Ali, and even the person who purchased the said areca nuts, he is also granted interim protection.
I have perused this one and Mr.
Yes.
Lordship
may
has
kindly
also perused this several times. So now the question is that there are several witnesses, accused persons. Their involvement is a bit separate for one. Some are directly related for hijacking, some are directly with the purchasing of those aircraft, some are bona fide, some may not be. This kind of things are there. So your petitions may be loaded, unloaded, but it was rejected earlier. So better to go for the case diary. Like you can. Case diary may be available also. Mr. Kusami, is there available case diary? I don't know.
Lordship, only one document may
Yes, several. I have
Lordship,
several matters.
Lordship may kindly peruse page number 22. The person who has purchased, it is alleged, he is also granted protection, Lordship.
Otherwise, in the rejection order, these 2 persons were stated to be the kingpin. This was the submission of the.
But nowhere in the earlier forwarding report, Lordship, nowhere our names were involved.
So let it be case diary be fixed. In the meantime, if it is available, so then please ask the office to keep it there, so that it can be perused on the next day. So we'll fix it on
short date, Lordship.
28 or 29 can be fixed. 20. 30 also can. 30. 30. No.
30?
Yes.
Oblige.
May I please, Lordship? Lordship, matter may passport for the day.
It is. Otherwise, we have received yet.
Yes, 10 copy has been received, madam.
Ten copies received, Lordship. And earlier, Lordship have rejected the bail on order is Lordship at page number 21. Until date, Lordship, charges are not framed, Lordship, yet. Charges are yet to be framed, Lordship.
Is it a charge sheeted one?
Charge sheeted one.
Okay.
Lordship,
So we want
Lordship,
to pass over for the day.
Lordship, it may fix on 1st June of first week of June, because Lordship on 31st May it was fixed for evidence on the trial court.
No, the additional
Last
fee has-
order or last order is of 6/5/2000.
charge is not
Four.
charge is
Till 6, Lordship. 6/5. So after that, we don't know, Lordship.
charge is already
Charge
framed.
has already framed.
And then
Fixed for
after-
evidence 31st May.
Then Lordship.
31st of May.
May.
You want to get it fixed on after 31st?
After 31st.
And the request made by the Rani also for the list matter yes. 5/6.
Oblige.
If the scan copy of the case record has already. In that case, you can call for the updated.
Status.
Call for the updated status of the case record. According to call for the scan. Scan copy of the case record. We call updated scan copy of the case record. We call for along with present status of the 5/6.
No, it's going.
Deeply obliged.
I please your lordship. Lordship, I am appearing as a legal aid counsel, my lord. It's a statutory appeal. Appeal may be admitted, my lord. And there is a delay, 267 days delay. Occurred due to legal aid provide me lately, my lord. So delay may be condoned and appeal may be admitted. My lord, LCR may be called for. There is a IA also, my lord. IA may be here after receiving the LCR.
You are legal aid counsel?
Legal aid counsel.
Yes,
Yes, I am appearing, my lord. We will file objection also, my lord. There are 10 years punishment.
Okay. We are not taking today, but the question is, what about your submission in regards to delay? He is in jail.
He is in jail.
Fellow is in jail.
Yes.
It can he report for. He get to IA to. Delay has already been called.
Delay question. Delay extra file question. Delay petition file करना है.
Yes, is it already condoned?
इसे condoned होके
Oh, okay. This one is okay. So delay is already condoned. Okay, then what remains? We admit the appeal. Delay is already condoned. Yes,
condemned. Let it come up for order.
Yes. It's a jail appeal can be admitted, I think.
Yes.
Hard MS. M does. M does. They run it from. Run it legal aid count for the appeal. So hard. MP comes. They run. Delay already controlled. Filing the delay of 67 days has already been controlled.
And there is also response number 2, my lord.
Oh, the response number 2 is there, na?
Yes, my lord.
It is admitted for admitted. Issue notice on respondent number 2. Registered. It's recording. Call for it. Okay, you take it. We're listing it after 4 appeal is otherwise that.
Deeply obliged.
Appeal is allowed.
Yes.
Okay, here the petitioner is seeking for interim custody of the vehicle that has been seized by the Gwalpa Police Station under Section 22C of the NDPS Act. So, my lordship, here the petitioner is the registered owner of the vehicle, lordship, and here also kindly see the FIR at page 20. The relevant page is 22, lordship. 11. Both the driver and handyman was arrested, my lord, and the vehicle was seized. And you also would find the seizure list at page 24.
Lordship, in this regard, we will take a report from the IO Lordship regarding Jimma. Jimma can I do? Report to the law.
The case is pending in the trial court, but special court at Gwalpa. Here the report has been, LCR has come, lordship. So why haven't further report from IO, my lord?
The LCR Lordship, it is not clear. It is the earlier order when it was rejected, Lordship.
Already
2020, 22
22.
Then from that on that day onwards, Lordship. So I'll have to take a report, Lordship.
But the case is most probably charge sheeted one.
Charge sheeted, Lordship.
Then where from you are going to take report? Report from
Because
IO belong to, I think.
IO only, Lordship, because the vehicle is in the police station. Only.
Yes, police station. That's why the petitioner is checking.
It
The
was
case is
rejected
in the evidence stage.
It is now evidence.
Yeah, yes, sir. And that has been
Just,
fixed
I
on.
just want to ask you, it is a evidence case. Have you filed any petition before the trial court itself?
Yes, yes. Lots
is
of
there any rejection order?
No. Rejection order is at page 32.
It is rejection order from the trial court.
Trial court, madam.
That is of Lordship 3/11/22.
Yes, my lord. At the time, my lord, we have filed the day after rejection, my lord, we filed this petition, my lord. We filed on this present petition, my lord, before this honorable court on 25/5/2023, my lord.
No, but the order which you have annexed.
Yes.
The order you have annexed, is it 3/11 of 2022?
Yes. Yes.
The question is that this order was passed earlier to filing of the charge sheet or prior? I mean, subsequent to the charge sheet.
No. Earlier.
It seems it is the prior, earlier.
Earlier.
So now this scan copy is this present status.
Present status.
So why? That's what I am asking you. Now this order which you have annexed before us, it is of 3/11/2022
Yes.
that was rejected
prior
to filing of the charge sheet. After filing of the charge sheet, that is the case is
No new petition was filed, my lord.
Why don't you file any new petition?
Because already
because
we
now
have,
it is just trial state.
This case is pending before this honorable court. That's why, lord.
Because what I'm saying, because sometimes it happens that the trial court is the best court to judge whether this vehicle or this will be needed for the evidence purpose or whatever. That's why I'm just asking you, why don't you file a press petition before bench? In that case, obviously you have to withdraw this one because the rejection order you have annexed, it is prior to filing of the charge sheet only. Now
Yes,
case
yes.
has been charged that now you have stated that is at the stage of evidence. So better to file a petition before the concerned court itself, I think. That will
Presently.
Yes. Because the scenario has been changed. Now it was rejected. I have seen there are report of the IO was also there.
At the time.
Considering those report of the IO
Yes.
true owner itself, it was not determining the IO could not assess the true ownership and all. So these are the reasons why your petition was rejected. Otherwise, if your vehicle is directly involved in the said commission of the offence of the commercial quantity of nature, that may be one of the reason, I don't know. But the order was passed prior to filing of the charge.
Yes.
So better to file a fresh petition.
Fresh petition one.
Yes.
Then we may be allowed to
You can
file the fresh petition before that is trial court. Trial court.
before the trial court.
Trial.
So should I pass the order or you want to withdraw this one? This just thing can tell me. Take instruction from your
Also,
client
would be
also.
pleased
Just-
to direct us to approach the trial court, my lord. So that
It is the scan copy of the LCR. right?
Scan copy.
Yeah, in the scan copy of the record, we do not find anything in fact.
Only the case there is that.
Can we be listed after 2, 3 or next week? You just take the instruction and tell us what is the status of the case at present, date, fixed date, also this kind of just information tell, because here we
Nothing
don't
is
have
there.
anything. Scan copy of the ulcer is also silent about any filing of the charge date or charge regarding the framing of charge. Nothing is there. So without knowing anything, it should not be passed.
Last entries of 22 only.
You take instruction from your client,
Yes,
present
Lord.
status of the case, and let us know, and then we will be
then it may be on 23rd, my lord.
23rd is the holiday.
Oh, 23rd.
Next week.
Next week would be.
Next week अपना read लो 28, 29.
Yes, 28.
It will be on 28,
Yes.
29, and it will be on 28. Can be given. We'll stick
Till-
it on 28.
yes, yes.
You just take instruction, let us know.
Yes.
Present status.
Yes. Also, we will submit the online printed copy of the order.
Whatever you can.
That would be easy for us to collect all. Yes. All right.
So we are listing it on 28.
28. Deeply all right.
List on 28. That is not here. That appears on court. For the paper, as well as this record. As on it. Yes.
It is your lordship. Lordship, may we please to turn to the FIR, which is at page 21, madam.
21.
Lordship.
Yes.
The lordship, may we please to turn to page 23, lordship.
Hmm. Yes.
May I read, lordship? With reference to the subject matter cited above, I so and so, presently residing at, would like to bring it to your kind notice that on 22/8/2020 at around 10:30 p.m. I was accustomed with an unwarranted situation wherein one Mr. Sambhu Sharma, resident of so and so, had entered and trespassed my house without my permission and forced me to come out of it and meet at his suggested place. On being astonished at the unruly behavior of Sambhu Sharma, when I had requested him to cite me the reason for such an unprecedented move of entering the house forcefully, the person had revealed that his sister, Miss Nimi Sharma, had fallen in love with my brother, Paras Agarwal, and would like to marry him, or else she shall commit suicide, and entire blame shall be shifted upon me and my family members. Thereupon, when I had refrained to move as per the coercive call of Sambhu Sharma, he had used abusive and filthy language to provoke me. Thereafter, being infuriated, he had threatened me and my family members of dire consequences and narrated that he shall plan a mysterious suicidal attempt of his sister and put blame of abetment on me and my brother. The culprit Sambhu Sharma had also threatened me that he would even trespass my shop at Jabbar Bazar and would cause damage to my property shop there. Things did not stop here. And today, on 23/8/2020, at around 9 am, things turned violent. With Sambhu Sharma, along with his brother Sankar Sharma, had called me again at Jabbar Bazar, and soon, when I reached near this place of Adgaon, they called me with they caught me with my collar and started beating me without giving me any opportunity to escape. Adding to the scenario, Sankar Sharma started beating me with wooden rod, first on my leg so that I could not run, then on certain part of my body. Resultantly, I had injuries on my body, which is visible on my right hand, below palm, above cheek and lips. Certain blows were punched next to my eye, upon my face, out of which one blow had left an inflated remark on my right side of my face. That, sir, in this regard, I would like to bring to your kind notice that my brother Paras Agarwal is not staying with me for the past 2 months, who had left his place for treatment at Dhanbad, Bihar, and would continue staying there. Moreover, I have nothing to do with the personal life of my brother, since he is free to take his own decisions as he is of major by age. That apart, his treatment is still going on and will be concluded by surgery. I also had words with my brother in this regard, who fairly replied that he is not in touch with this girl for a very long time, and tentatively for the past 8 months he did not even texted a message to her. Therefore, calling or talking with this girl had never arose. While writing the aforesaid incident, it must say that it took immense pain for me to narrate the same before you, but still then I end up stating that I had been threatened and full efforts were made by these culprits to kill me today, and even I apprehend a violent turnout of the culprit, Mr. Sambhu Sharma, who might come up at my office tomorrow and cause violent attack on us as well as on our property and belongings. Hence, under the circumstances, we might seek your immediate intervention, help and protection. Now, Lordships, this FIR was lodged on, Lordships may mark the date on 23/8/2020. This is at page 21, madam.
23?
23/8/2020. Now, Lordships, may please to turn to page 25, madam.
Hmm.
25, Lordships, may please to mark the date, Lordships, at the top, 24/8/2020. Next day, madam.
This is another affair.
This is another FIR lodged by Nima Sharma against me, madam, against the petitioner. The earlier was my brother has lodged it against his brother, madam. My brother Sanjay Agarwal has lodged against Sambhu Sharma, who is brother of Nima Sharma. Now, Nima Sharma today on 24/8/2020 has lodged this FIR. Operative portion is at page 27, madam.
Yeah.
27, madam. May I read, Lord? With due respect, I beg to inform that in the year 2018, I came in contact with the accused person above named, and gradually friendship developed between us. and after few days he promised me that he will marry me, and accordingly I also believed him, and taking advantage of my belief, the accused person above named established physical relationship with me several times. That in the month of November 2019, me and my known persons, namely Sheikh Abdul Nadim and Sheikh Abdul Ghaffar, went to the house of the accused person to talk about my marriage with the accused person. But the father of the accused person straightly denied, and thereafter, as there was no hope of my marriage with the accused person, I asked the accused person to end our relationship, but the accused person promised me that he will marry me in any condition and asked me to continue the relationship, and thereafter also he had physical relationship with me. That whenever I asked the accused person to marry me, he used to show various problems and used to tell me to wait for few days. And since March 2020, the accused person started avoiding me, and whenever I used to call him over his phone, he did not pick my phone. Having no alternative again, in the month of May 2020, my family members went to the house of the brother of the accused person, so and so. But the accused did not say anything, and now the accused person is threatening me that I will have to face dire consequences if I ask to marry him. This is the allegation, Lordship. On the basis of this allegation, case under section, my lord, 506 and 493 of the IPC was registered. Thereafter, Lordship's charge sheet was filed against me, my lord, on 28/10/2020, which is Annexure 3, my lord. Lordship. 28/10/2020, Annexure 3, my lord.
As paid.
29. Now, Lordship's charge sheet has also been laid down under 506 and, my lord, 493. Thereafter, Lordships, what has happened is that the trial has begun, my lord, but Lordships, there is no cognizance order of the learned trial court. That is reflected in the order dated 13/7/23 passed by the Lordships in this matter, man. Lordship. My lord, may I read this order, Lordship?
Which order?
Order
This
dated
court?
13/7/2023.
Yes,
Passed
I
by
have
this
already
court.
seen.
Now, Lordship, what has happened is they have filed one affidavit in opposition. Which is at, my lord, page 2 of the affidavit in opposition may be seen, my lord. Affidavit in opposition, Lordship, filed by the respondent number 2.
Is that page?
That page is, it was filed on which
okay.
date?
Okay.
26 March. Man.
Yes. Yes.
Paragraph 2, my lord. May I read, my lord? That at the outset, I humbly submit before this court that I had a love affair with the petitioner so and so. I liked him and he also liked me. But due to some family issues, we could not marry. I had lost the FIR dated 24/8/2020, Annexure 2 in the criminal petition against the petitioner. I humbly state that the FIR was lodged in haste and due to misunderstanding between me and the petitioner, and petitioner did not indulge in any criminal act. I believe that the petitioner had no criminal intention while having the affair, with me. Petitioner's brother had lodged the FIR dated 23/8/2020 against me, and therefore I also lodged the FIR dated 24/8/2020 against the petitioner. In these facts and circumstances, I do not want to press the charges as mentioned in the FIR. Now, Lordships, paragraph 3 may be seen, my lord. I have resolved my differences with the petitioner and I have friendly relationship with the petitioner. Moreover, I have also got married on 8/7/2022 with Vikas Sharma. Furtherance of instant criminal case will serve no purpose, and I do not intend to continue the criminal prosecution of the petitioner, and the continuance of the same is doing injustice to him. In the facts and circumstances, I would not like to proceed with the criminal prosecution of the petitioner and pray to this honorable court to quash and set aside. Now, Lordship, we had a love affair that is admitted fact, my lord. And since my brother lost the FIR, they also, respondent number 2 also lost the FIR. Out of grudge and vengeance, this FIR has been lost, man. Lordship may be pleased to quash this, Lord, in view of the affidavit also.
My pleasure, sir. Lordship, as per our instruction received, we have no objection regarding their petition, Lordship, and it may be allowed, Lordship.
Dear Mr. P.
PK Garodia, madam.
Dear Mr. P.
J. Hussain.
Respondent number and Mr. Happy. It is Mr. that your brother loves the FIR.
My brother, Lord.
That earlier his brother lost the FIR. He put the respondent. And the other Sharma is
her brother, madam. Her brother.
Against one.
At page 24, madam.
His brother's name was
Shambhu Sharma. It was also lost against the informant, madam. Nimi Sharma also. Shambhu Sharma, Shankar Sharma, Nimi Sharma. At page 24.
His brother Ajay Agarwal also lost an FIR against the present one number 2 along with his brother Sabra and Asma and one other case with some evidence of that is that they said the Shambhu Sharma along with others vote is him to make the present one number 2, and there was also some evidence of assault on the brother of the president. That state FIR was lost on 23
madam.
And thereafter the present FIR has been lost by 01 number 2 on 24/8/2020, which is already registered under charge sheet has also been filed under 56 law, and charge was also framed against the present petition under section 5 to 4 93. However, the Internet Court did frame the charge without even taking the cognizance of offer, which is also reflected while while the reflected in the order by its court dated 13/7/2020. However, during the Benedictus state case, the petitioner reference number 2, the informant filed in their affidavit in opposition, where it has been admitted by her that that she had a love affair with the defendant, and but due to some family issues, they could not marry each other, and she lost the affair on 24 April 2020 as the brother of the victim also lost an affair against her brother. At present, but it is admitted that the victim had no criminal intention while having affair with her, and at present they resolve their disputes in principle. And he already got married with another person named Vikas Sharma on 8/7/2020, and thus she does not want to case, which is pending for the court of Planet GMHC. The pending contributor the criminal case being numbered here 166 pending before the court of Planet Kamrup, because it arose in connection with factor in connection with alternate case number 113/2020 under section 5 by 495. The biggest threat is the exercise of power can be exercised for what the criminal case that of charged by it was that the scope of the task of remote and hence even if remote even if the process is allowed. Okay, so the Internet account one number if it has no objection thereof by what that as matter of course and if okay, this is
Yes. Obliged. Obliged.
May I please, Your Lordship? Your Lordship, kindly the matter may be passed over for the time being. The senior is on leg at C17. Yes.
May I please, Your Lordship? Look, this is again a case of a rejection of the prayer for Jimma. Lordship may kindly see. Special PPS. Piece of.
Can it be taken just after some time? Some forest special PP has to be intimated. I will just intimate.
At 2 o'clock, man.
Whenever he comes,
You'll be available in this court?
Yes, yes.
We'll try to contact you.
I will. Yes.
This is regarding Jimma of my jewelry shop, my lord.
It's okay.
This is my only income source, my lord. That is rejected
No,
by
the other side is already appeared, I think.
18. That's it. Yes. Majar Bhuiya. Jimma of what?
Jimma of jewelry shop.
Oh, jewelry.
But they have already appeared, I think.
Their names also reflected?
Names are also reflected. Na? Can it be...
Otherwise, Jimma can be given at those Ambalal Desai.
This is the only source of income, my lord.
Acha, shop is closed.
Close. This is sealed. My lord, my shop has been sealed, my lord, from the date of arrest. I was arrested, then I was released. But my shop was, my lord, sealed by the authority, my lord, which is my only source of income. And some customer also facing some trouble, my lord, for the closing of the shop, my lord.
You have to see
We
why
can
it
get
has
a
been-
report also. Normally, we get a report from the police officer whether it is sealed by the police officers.
No, department, municipality.
Oh,
municipal.
Yes, ma'am.
Yeah, who is there? The council? Is there any standing council for GMC is also there? GMC standing council will क्या
Response number 3, my lord.
GMC standing council is available or
Respond number 3.
Three,
I mean, I think this notice is not served. No.
Notice of
Only respond number 2 appears. 3 as well a deputy commissioner investigating. 4 I can appear, but 3 a government advocate can appear.
yeah, that's what. For 3.
For 3?
For 3, yes. You can appear for
4.
Say 1 also you can appear.
1 I can appear as well as 4. But 3 I'll inform government advocate to be there.
Response number 12 filed an evening opposition, my lord. He supported my case, my lord.
Who supported your
I am in the end. He supported my case. Response number 2, my lord.
No, how he is respondent number 2? He is an informant.
No, he is my lord. I am in a rented house. He is a landlord. My shop was, my lord, in his rented house, my lord.
Achha, he is the owner.
He was made response number 2, my lord.
Go through the case. I don't know what is the.
And the case is also my not 380, my lord. It is my 30411. Stolen paper has been found in my house.
Seal kora hedu kora se. Kiba ase document?
I blame my lord for the timing, my lord. I mean, because my lord, there is problem is facing by the
Case
customer
diary, I
also,
think.
my lord.
Case diary will be.
Some
Case diary
customers
will
are
be
facing
required,
problem.
I think. Mr. Han?
Lordship?
Case diary will be required, I think. I don't know where this seal order is there.
I mean, page number 34, there is an order of the deputy commissioner. They are requested to submit trade license copy, commercial tax, and all
I have
those.
submitted. That is already submitted. That I have
didn't see
submitted.
it.
Nothing has been wrong. But I have submitted earlier, my lord. Document submitted by me.
A
It
sealing,
was earlier notice. It was dated.
sealing order to ase nahi? Seal kora order to?
Order देने seal करा है. Order seal order ना करे कोर्टे apartment लिखे seal करा है.
Oh,
Immune order है.
acha. It is in the impugn order, I'm told, that the sealing
34.
fact is there.
Seal in person to order of this court.
Yes.
And I mean, not court below.
Yes.
Court below's order was there.
My lord.
Huh.
Okay.
According to the prayer submitted,
Order,
by
import order is
GMC,
my page matter 34, my import order matter
35,
35. 35 matter. Import order matter. In this order matter, there is a environment matter, the shop has been matter sealed. The only that sentence is there matter. But no order of shown.
It is there now in para number 6. It is there that according to the prayer submitted by Guwahati Municipal Corporation has sealed the jewelry shop. So court has not passed any order, I think.
let the government advocate come and they get a report from the deputy commissioner.
Yes, you can inform the government advocate.
I'll inform the
Yes.
government advocate.
Yes, I'm a short date may be given.
You want short?
I said, she's there indeed.
She's there only. Okay then.
Seal course dukan এখন. So you are there for response number
Please,
3.
Yes, that is
I'll obtain instruction for now.
She'll obtain instruction and a report as well. Seal card দরকার আছে না না লাগে?
An extra copy may be served upon me, ma'am.
Heart, Mr. S.K. So, confident number 1 and 4. The MS
You, Sharma.
Sharma, appeared of state response number 3 and submitted by her to become according to page number 10. And I will have to take of the government. Most further, the council for it hereby asked to provide an extra copy to the responsible. And this accordingly, how many 1 week will do? Yeah?
1 week, my lord.
1 week.
1 week.
Did you want any fixed
Yes.
date? Want
That-
any fixed date?
Let me fix matter.
It will be on June 5th of June.
Yes.
Take instruction by the time.
Yes, my lord.
Because we don't have anything here. But under what order it was sealed?
Yes.
How it was sealed? Because municipal corporation most probably he is saying that it was under the corporation most probably passed the order of sealing and all that. But there is nothing is here, and a court order is not on that. Court is order is that it has already been sealed.
Yes.
Prayer was rejected.
On the basis of IO's report.
Yes.
Yes, ma'am.
So there may be some order on the sealing of the jewelry shop.
Madam.
Because jewelry shop is since when it was under seal?
Matter.
Since when it is under seal?
It is matter actually that from the date of matter arrest matter, his arrest matter, 31st of December 2003 matter, 23 matter.
2020.
Yes.
So it's the
Yeah, on that day I was arrested matter. From that day.
we'll see.
I'll obtain instruction.
Come on, right?
এক সপ্তাহ time I do have it.
It will put up. Yes, 19 you are here.
Lordship. It is a statutory appeal, Lordship.
Okay.
He was convicted, Lordship, under Section 10 of POCSO Act, Lordship. 9F read with 10 of POCSO Act, Lordship, for 5 years, Lordship.
He is in jail now.
Lordship, he is in
One
jail.
eye is also there.
I is also there, Lordship. 5 years short-term punishment, Lordship.
But the
Conviction under POCSO matter.
no, POCSO is there.
Yes.
And the question is that one you have not taken step for the response number 2. I think.
Lordship.
जी आइते हैं ना
I heard
আৰু এদিন আগতে আহিছিল।
so I thought it not hard strategy. The next step is that not strategy also called for healthcare. Okay, it is admitted. the list.
Lordship, I is
You
there.
take steps for. I will be most probably after the
Receipt
next
of
week.
notice.
After this.
Lord.
Since when he is in custody?
Lordship, since date of judgment, Lordship, 29/4/2024. Lord.
29 4.
Lordship.
Most probably you are going to file the.
Yes. Objection is not required, Lordship, because below 10 not years. mandatory, but
Not
mandatory.
mandatory.
But we
If
can
you
file
want
because
to, you
in
can, or otherwise, public.
Lordship.
Yes,
Obliged, Lord.
admit to it.
After 4 weeks.
After 4.
This item is regarding appeal against acquittal. Here,
Appeal against acquittal.
appeal against acquittal. Okay. Here, there is no IA. In the prayer portion only in the interim we have prayed for stay of the
What to stay?
operation of the impugned judgment, Lordship. Dated 79/2022, Lordship will find the impugned judgment is in.
By staying the impugned judgment, what will serve your purpose? Okay, let be admitted. Be admitted. Yes, Sharma. Goswami. Hard straight. Hard straight. Snap. Take dated 79. To notice to score number 2 to register it as also called it is admitted. We are listing issue may be done. We are also calling for the case.
Lordship. Development.
May I please, Your Lordship? The criminal petition, my lord, Your Lordship, kindly see the impugned order is at page 28. Page 28 in excerpt 4, my.
Yes.
My lord, here, interim maintenance has been granted on the first day.
Oh.
In our High Court already said that it cannot be. Both parties should give their statement of assets and liabilities, then my lord it can be considered. And on that day we took time for written statement and that was allowed also. And second price totally incorrect, my lord. The impugned order, the opposite party has admitted that petitioner is the wife and child in her lap who is 2 months old, has been feathered by him. We even did not file the written statement on that day. How this observation, my lord? And on that day, my lord, this interim order has been passed. Issue.
Where is the order where you file pray for the WS, time for WS?
My lord, it is reflected in the order itself.
Order itself.
It's
Gotcha.
we have relied our High Court order page 30, my lord, and excerpt 5. And relevant para will be page para 8, page 32. In paragraph 65, that is relied, that is the judgment of the apex court. And this judgment has been relied by our court, our High Court. Page 32, paragraph 8 and 65, Your Lordship, kindly see. Merit. The party claiming maintenance either as a spouse or as partner in the civil union, live-in relations, common law marriage, should be required to file a conscience application for interim maintenance with limited pleadings, along with an affidavit of disclosure of asset and liability before the court concerned as a mandatory requirement. It is the mandatory requirement. On the basis of the pleadings filed by both the parties and the affidavits of disclosure, the court would be in a position to make an objective assessment of the approximate amount to be awarded towards maintenance at the interim stage. That is the view of the Honorable Supreme Court. And this view was taken up by our High Court, and this order has been passed. That is page 30. In our High Court's observation, page 34, paragraph 10. Here in this case, having gone through the impugned order dated so-and-so, I find that the petitioner and also the respondent have not submitted their affidavits disclosing the assets and liabilities in the aforementioned proceeding before the learned court below before deciding the issue of interim maintenance as mandated by the Honorable Supreme Court in paragraph 64 and 65. What I in the case of Rajneesh Supra and also in the case of Aditi alias Miti, though the petitioner has sought time to file objection, the same was refused by the learned court below. In that case, it was refused, and in my case, it was allowed to file written statement. That being so, impugned order cannot be withstand the legal scrutiny, having been passed, ignoring the law laid down by the Honorable Supreme Court. This is my case.
Yes, but I need interim, my lord, but this much can be followed. Law is clear, my lord.
We may be given opportunity to file, my lord, written statement stating that all the filing affidavit. Then, my lord, the court may decide.
But it is for the interim only, my lord. So time frame may be given, my lord. Otherwise, delay tactics may be there.
We pass a time frame order definitely, so that an interim prayer for interim maintenance can be done.
Can be considered. This order may be set aside, and we may be given an opportunity. Mike.
So it is disposed of. Your petition is allowed. We pass the order,
Obvious.
and definitely time frame will be there. We pass.
Mike. Obvious.
May I please your lordship?
26.
26.
After.
Right. Now we are ordered for the 20. Yes.
My lord, item 26 may be taken after sometime, my lord. Okay.
May I please your lordship?
Yes.
I'm the petitioner. I am matter will be fixed for hearing, my lord.
No, as per official steps not
Taken steps as per office. As per office note, there is a response number 2, I think. We have not taken.
It's not taken. As per official.
It's a case of birthday 66 or whatever. So one respondent number 2 is there. Srimati Bora. Takes it. Her URMS?
BDAS.
Her MS BDAS. From the office note dated 22/3/2024. It is that the states the evidence according to the evidence registered date of LCR we have received. No? It will be listed after 3 weeks. Within 3 days of, within 5 days you take steps for the response. Because we have already received the LCR also.
Note 28 is ready for hearing one.
It's already ready.
Oh,
LCR ready. 2 is already appeared. I think.
Lordship.
Number 2 is.
Name shown, my lord.
Yeah, for
Other is not necessary part now.
anyway, they
Lordship.
already appeared.
Lord.
To have MS as maybe as maybe the that we have already received. It's a matter of
New matter. my lord.
23.
So usual course it will come, my lord. Normal course, my lord.
Yes.
Lord.
Four.
Ole.
Lordship, as per office note dated 1/3/2024, they've taken reference to the order dated 26/2024, and they've said that steps could that there's no service report available, but steps were taken through the district magistrate. But as per order dated 22/1/2024, steps were supposed to be taken through the CJM, Dibrugarh.
Step on 2.
Respond number 2.
2 and 3.
Or 3 is complete.
3
is complete. We can take fresh steps also.
To CGM. You want to take the step to CGM?
Yes, your lord.
Otherwise, it was for district magistrate.
Yes, they did through district magistrate, but it was supposed to be taken through CJM Dibrugarh. Wide order dated 22/1/2024.
MS Dwara.
K. Bhattacharya.
Your state is 1.
State
you are
by-
here for 3?
Yes, I'm for 3.
1 for 1. As per order dated 20/01/2024, the petitioner was asked to take number 2 to the CGM Dibrugarh, but from the assessment it is that it was the state body. The petitioner is thereby asked to take steps on response number CGM to CGM body. 3 after 4.
4 weeks, lordship.
Yes, after.
Okay.
We have already received can copy also. Can copy the
Lodge.
Right. Oh, আহিলে ন already. 30.
Yeah, please, your lordship.
Yes.
My lord, in this appeal, my lord, conviction is 7 years, my lord. Already more than 1 year in jail, my. And earlier, my lord, 3 months. Now, my lord, after passing the judgment, my lord, more than 1 year in jail, my lord. All total, my lord, 16 months almost in the jail.
So what is the term of conviction?
7 years.
7.
Yeah. So, my lord, matter may come up for hearing, my lord, and in the meantime, my lord, my lord, the appellant may allowed to go on bail.
This I is for
Bail.
custody.
So there is an office note, my lord, that some steps it is ordered for taking steps, but since no my respondents are arrested and respondents so steps cannot be taken. Reflect on the record. Nine.
Otherwise,
they have
because case was not really convicted under 376 also.
yes. So at least
Formally,
victim has to make the party.
formal
Rosima, kindly say 9/2/2024, my lord, order.
9/2.
Yes.
Office note.
Office note, yes. Sir.
Office note or court order?
My office note, ma'am.
9/2.
Yes.
Order of the court.
Order of the court or office note?
Mala, I am confused, ma'am. Sorry, ma'am. And either it is the office note or the order of the court.
Okay. 9/2024.
Yes, ma'am.
Nine.
Yes, I reflect.
Read. Perhaps in another case.
Case conviction is the prosecuted for under not party, but victim not party.
He is not made party, but in appeal that he is party. No.
No, ma'am.
No, ma'am. Made party.
There is any repair. No, my lord, the victim, my lord, is not prepared to meet a partner. This is not, my lord, like that.
It's 750.
Yes.
Otherwise, but this 750 is there. Anyway, if not prosecute the case,
He is a, my lord, married. My lord, married. More than 16 months in jail. And my lord, he has, my lord, 2 school-going minor children. And I have annexed the
at the
birth
time of committing the offense, should have
My lord,
he
he
should have
was
think over all these
engaged
things,
as a
na?
driver, my lord. 10 years
He
his service,
He should have think.
my lord.
At the time of committing the offense, he should
Yes,
have
yes.
think about his family and all.
Yes,
that.
yes,
He
my
did
lord.
not.
My lord,
He did not think of his family.
my lord, he was engaged as a driver, my lord, and he served 10 years, long 10 years, my lord. And my lord, only
You have gone through the record.
No, my lord, I have not gone for them because since I am of the belief, my lord, that some notice has to be issued, my lord, to the victim, my lord. Earlier there is an it was mandatory as per the decision of the honorable court, but some notification came after that, my lord, record notification. That,
In every application.
so
yes, my lord, that recent notification is there regarding perhaps, my lord, Now it is not mandatory after the notification. Notification.
Confirm it then.
Yes,
And
ma'am.
it-
Yes.
Or otherwise, okay, go by the copy. There
Yes.
is some evidence because the case of conviction term is of 7 years. So if you have anything to say, go to the record. If you by the time can consult with the notification also.
Yes.
But as per his submission, he is already behind the bars since last more than 1 year.
Yes. No, it's 7 years of punishment.
7 years. Including the
1
third-
year, 4 months.
Huh?
1 year, 4 months.
4 months, not after the conviction, prior to
Yes.
that he was
Yes.
there. Already including all those.
Yes.
Now 1 year and 2 months. What to say? What
Day after tomorrow?
Day after tomorrow? On Wednesday?
Wednesday.
Let us see, can it be possible or not?
Yes.
Because Wednesday...
Oh, yes.
It
is not a regular bench trial.
Regular, but the...
Yes.
People party.
Yes.
Next week maybe.
Yes.
Maybe next week.
No,
Next
no.
31st?
31st. No, 31st.
At least more day will go. At least more day will go.
More?
More day will go.
Done all this. That's good. Or day or go up.
Obligement.
May it please you.
Yes.
Praying for suspension of the sentence. The appeal has already been admitted. Let me kindly see page 50, my lord. This is the FIR. FIR says, my lord, my whole purpose would be, my lord, to show you before this court that the whole incident has taken, my lord, on a spur of a moment. Initially, the FIR says, my lord, he was hit by a rod. But only out of 14 witnesses, 2 witnesses are there. They are saying they are eyewitness. One is wife and mother. They said he hit by bamboo. And one accused, my lord, PW3 says, my lord, 2 accused were, my lord, injured. So this other accused, since this one of the petitioner, this was not discussed in the judgment. So from the records, my lord, I would state where I can show that there is no intention and knowledge. And this has been, all these things has occurred on the spur of a moment. And your lordship will just kindly see page 50, that FIR. It says, my lord, 2 p.m. so and so, suddenly the accused persons armed with dao, stick and spear, very serious, my lord, and iron rod, garrowed him in front of his house. The accused number 1 assaulted him with iron rod and badly injured him on his head. The other accused persons also physically assaulted him with stick, as a result of which he became senseless and fell on the ground. So after that, my lord, he was shifted to hospital, then he succumbed to injury. Then PW, out of the 14 witnesses, your lordship kindly see, all these witnesses, they are not eyewitnesses, and they say, my lord, they have not seen the incident. But important is, my lord, PW3.
With lordship's permission, my lord, may I intervene, my lord? Perhaps in this case also, my lord, steps not taken.
Steps you have taken. Steps you have taken. That is all
Whether
the
it is not complete,
complainant. Well, he is not a necessary
This-
party, your lordship.
Because
He is
he is
only-
added as response number 2.
You have added
Yes.
Yeah, that
Yes,
but he is not not mandatory to hear him at the time of suspension of the consultation.
if you have added him as a party, so
Yeah.
why don't you take steps?
Steps we have taken. Today is only
I'll see 1/12/2023, my lord, of this court.
What?
1/12/23.
Yeah, steps we have taken.
Office note of 1/12.
the office note or the lordship of my
Make it. So the FIR says that he hit by all this rod and all, but in the deposition of the eyewitness, it says it was hit by bamboo. So and there is no forensic report to that. So therefore, my lord, there is no intention and knowledge. Your lordship, can you see the decision? The witnesses' evidence will clearly show that whole thing occurred on the spur of a moment, and therefore there is no ground at all, my lord, to convict him under section 301.
This is the order, madam. And there is no instance of taking steps in the office. In the office.
Order was there.
What?
Because an order was there.
Order was there, but
In the office note, my lord, I have not
You
found.
have not
madam.
taken.
In the office note, I have not found.
No, no.
I'll let it come on next week, my lord. I'll give you a report.
Do you have
from
any
tomorrow.
acknowledgement receipt and all? Because if you have taken steps,
We have
we
taken
don't
steps.
have
This much I
any.
know. 23 document by postal.
We have to register.
Open it. Anyway, let it come next week, my lord. I'll take information from my Mohori.
Okay.
It is.
मैंने कोई reflect करा नहीं.
Oh. I've got this acknowledgement, but let the office reflect, man. In the meantime, I'll also try to find. Next one, Tuesday.
Next month, okay?
Monday or Tuesday, man.
Tuesday.
Let it be.
Tuesday will be 20.
That will. Office may also, my lord, check that step. Office may report us.
I
Oh. Apply.
Yeah.
May I please, Your Honor? Your Honor, on the last occasion, we have prayed for adjournment on the ground that we will go for mutual settlement, and the mutual settlement has been arrived, and we have paid an amount of half of the amount, almost half of the amount has been paid, and only 40,000 is left. The total amount is 1,10,000, and we have paid 70,000 to the petitioner, and another 40,000 is pending. We will pay it by the next month. So the matter may be placed again next month by 21st. By that time we will pay, and the matter will be withdrawn by that.
now so this I was filed the interpreted application for the payment.
I was filed by me. I responded number 2 in the criminal revision petition matter.
It was filed by you.
Yes, ma'am. And that can be closed, my lord, because they have already made a part payment, and so the IA has become infractus at this point. And the revision petition may be listed on 21st of June, so that the remaining balance amount can.
It was also before Lok Adalat.
No.
Earlier it was put up before the Lok Adalat.
Yes, earlier.
I Oh, yes, per UT 50% is 1,10,000.
No. 1,10,000 is the total compensation amount.
Now we have paid
70,000.
They have paid 70.
already.
Yes.
You are Mr.
S. Rapa.
Art S. Rapat. As the
RR Musik.
RR contact number that this is an application filed by the contact number complainant for the payment of compensation amount pending hearing of the connected criminal justice for 20 by the incident with paid by the response number that it better its context and other uh, for paid out from the competition and that but it paid for both of the or considering the present act of recorded at 1 week you need? How many?
Next month, Your Lordship.
Next month.
21st of June.
At the-
Obliged.
I said.
Yes, please, Your Lordship. Sir, I have not gone through the report. Lordship. A notice was issued to respondent number 2, Lordship.
Notice was issued.
Yes, sir. Earlier it is awaited, my lord. Service report awaited on last occasion. Now, service.
Sikha passport. Sikha passport. One Sikha passport put her signature. Without anyway, it is can be jumped this up. I think. Who is your the respond number 2?
It is Sanu passport.
Sanu passport.
Since the record is available, Lordship, interim stay may be considered, Lordship, because the trial is going on, Lordship. Here the section who is our
Informant is Sanu passport, my lord.
Yes, Sanu passport.
Yes, sir.
Here-
So who is Sikha passport, my lord? That is a
So who is Tikha passport is not there.
Yes, ma'am. And there is no reference in the FIR also, ma'am. There is no reference in the FIR also regarding Tikha passport.
Tikha passport who received that the
Yes.
notice.
Yes, ma'am. Then who
As
is
per the office note also, Tikha passport is there, but relation is not known.
relation not
How
known.
she is
How she is
related with,
that is the
yes,
problem.
that is the problem. Let us await for some next week.
Yes.
We will reflect the order that the one Tikha passport has already received. But relation is that not await for next week. One someone may appear also because it is a 354A matter.
Lot.
If there.
This
We
is
just
section
wait for 15 days. Thereafter we'll continue the matter. I don't know who is Shikha in fact. We also don't know.
Maybe it may come after 1 week or it may
May
be
not be
fixed.
possible.
Because the section here is 354, other section is not attracted to the petitioner. The petitioner tried to compromise the matter. He is an advocate. So these sections are not here. The even what is stated in the FIR and what they are saying in the statement or what is in the charge sheet, it is totally different. Here the demand was made for 1 crore. Something written that 1 crore of his Koila assignment amount, which is entered with this much, this Ma Kali enterprise of here. When we refuse to give him such amount to that he touched our bodyguards, these are the allegations. This was main allegation is made against Anjan Das. Now, Lordship, here the search sheet has been submitted. Search sheet says something else. Totally a different 15, Lordship, page number 15, Lordship. Here, totally a different story has been stated. Here, during investigation, it came to light that the statement of the victim Binod and his family members were in the house of Dismas at around 6. Anjan Das called him for giving the land and its documents that Binod passport purchased from Nayan Kempur. It could be noted from the statement of female victims that apart from Anjan Das, name of the other accused person could not be identified. Here they say no one is identified.
Subsequent date was
Yes, Lordship.
there. As per office note, scan for stop as per office. 16/5/2024. The third be appearing signature of one the cover. How Mr. Goswami, whether what to do it, whether can be to this up. Petition, it is not.
Yes,
One passport with
there.
signature, but
Yes. Who is it's difficult to presume that.
Since the address is
so I
same,
have
Lordship.
not mentioned it is the team to be served. Just we will listing this the matter.
Just
if someone
appears,
appears,
then
then
someone
it's
might
okay. Then. After 2 weeks, we are listing going to. After 2 weeks, you want at 5th date?
And date.
12th. We are listing on 12th date. Let us see. One may appear also. For the
It may come for admission then. Lord.
Admission?
Admission.
Can it be?
Come for
We come for order for
because
12/6.
It may give an observation that the matter will endeavor maybe made to dispose of the matter.
Obliged.
May I please, your Lordship? Lordship, here service is completed, my lord. When could be supplementary?
Completed.
Matter may come after 2 weeks, my lord, for consideration of the bill, my my lord, in the supplementary file, my lord.
Devon Chodo.
এখানে
Itu Devon Chodo. Itu date of 20. Yep. 2020. 2000. Then. Okay. Okay. Your good name?
A guy.
A guy.
Yes.
From office note. From office note. We have received the LCR.
Yes, my LCR received.
I office note, but considering it's not in the so we are listing it to be deemed to be served. So otherwise, your appeal is also ready for hearing it, but your petitioner is behind the bar since when?
It's been behind the bar for 10 months. my lord.
10 months. What is the convicted section?
Section 8 of the POCSO, my lord, and 448 of IPC.
8 of the POCSO. So we can hear the IF. Please hear the IF. If you receive an order for so just
Much obliged.
In D5, my lord, earlier we have prayed for filing objection, but I've seen from the record, my lord, no objections has been filed, my lord. Of course, my lord, my learned colleague has made a prayer, my lord, so I am repeating that prayer, my lord. For 10 years punishment.
My lord, with regard to service, my lord, it has,
954.
I have surveyed to the CJF jurisdiction, my lord. The Zarikarov report reflects that the Khuri She has received it, my lord. It is in the supplementary file, my lord. As per the Jarikaro report on the back side, my lord. This signature is there, but the subject to the system. It can be deemed, my lord, service to be complete, my lord. And with regard to
No, but I mean, where from you? Kudi, na?
my
But
lord, back, my lord,
no,
it
no,
is-
not Kudi, but she also put her signature.
She
She's personally served.
my lord, that is
Normally Rabha. She's normally Rabha.
normally Rabha, my lord.
Normally Rabha is there,
Normally
and then
Witness.
someone has put his signature, who is Kudi to
Yes.
normally Rabha.
Normally
It's not
Rabha.
a person.
Person. And my lord, with
Here
it-
the office note also speaks in that manner only.
my lord,
The CJ model.
my
Achha, it's not there. Received from
my lord, yes. And my lord,
it's served only.
Yes, ma'am.
Otherwise, you are taking time.
Yes, ma'am. Only
My
ma'am,
lord.
a week time.
because
A
this
week's
is
time.
304 part 1. This is a case, my lord, 304 part 1. No eyewitness. Only one witness, PW5, that has denied. And my lord, interestingly here, my lord, postmortem report is where the injury. Postmortem report is not proof. Inquest, there is no inquest also. The IO says this is not the postmortem with regard to death. Because what happened was that there was a ZD entry, my lord, initially, and FI was different. Postmortem was conducted on that basis. So, my lord, the postmortem is not proved in this case. There is no inquest. So, my lord, 304 part 1 continues.
Postmortem was not proved by the
Yes.
through the medical officer.
Medical officer, but with regard to the state FIR, the postmortem reflects a different GD. So, if the medical officer developed, the report has to be same, either the FIR or the surface to reflect. The ZD number is different with regard to the postmortem. So the postmortem is not proved to that extent. There is no inquest, no eyewitness, no independent eyewitness, only eyewitness PW5 who has stated that I was not there. So my lord, that is my urgency. That is the reason.
Since when he is it?
My lord, since 2012, 2023, and 62 years.
We are seeking 1 week time.
My lord.
Pardon. Office note. Extra copy. Your after 1 week or need any day?
My lord,
29
either
or 30.
29 or 30 as per lordship convenience, 29 or 30.
Yes.
30?
No.
My lord. That's a Thursday, my lord.
Please.
No.
Oblige, my lord.
May I please the lordship, but as far as the come for condemnation petition, and already the notice has been served to all of party.
Poxoni.
No, cannot 326, madam. Delay is there.
What was the delay? It was
Actually,
a
their
delay for
counsel who was engaged for the appeal in the court.
No, what was the delay?
Delay, yes, sir, 2,161 days, madam.
Yes.
That is almost 5.
Had it been
Actually,
little less,
huh?
had it been little less,
No,
it had been-
no, their explanation is there, my lord. The counsel who was engaged, he was suffering from ill and he expired. Thereafter, his petitioner has got no information, received no information, as he used to work outside as a laborer. I've stated this grounds, my lord. Yeah, lordship.
He is outside, inside where he is.
No, he was in the Assam. He used to work in
No,
different
he
places.
is not in jail.
My lord,
He is not in jail.
not in jail.
Then he received big delay.
No, already the case has been filed against him, my lord, as he warrant was issued, and then is in filed the suspension sentence. I have filed a petition also. The other IA is related to that, my lord. But in the first one, delay has to be condoned. So
No, he was
at para
perhaps
5, my
directed
lord.
to surrender instantly. He was
Yes,
perhaps
yes,
directed to
but
surrender.
due to his no communication, lack of communication, because Lordship may kindly para 5 may kindly refuse. That's death
What is the
certificate.
perusal? But the question is 161 is the
There are instances
So,
where there was
yes, can't go on.
long delays are also because of the revision conviction is there mandatorily provision.
In fact,
before
there is
revision,
a
my lord.
conclusion in the judgment that he should
Yes.
surrender before the trial court
So that is
in
there.
forthwith.
I mean, I'm not-
And the sentence was only for 2 years.
2 years. I have not denied that fact, my
So
lord.
he was absconding, perhaps. So he was
Not absconding, but that counsel is expired, my lord. That death certificate also have issue annexed, my lord. At page 21, my lord. The counsel he was engaged, my lord. He was.
But he was not on bail. He should have surrendered.
He was on bail, but he had got no communication regarding the judgment, my lord. Most they are only interpersonal rustic villages, my lord. So he was depending on his counsel to receive information, but after a long delay, but when he got information about the warrant and all, then he came, my lord. Otherwise, he never avoided it, my lord. So it will be mandatory bail provision, my lord, for revision, my lord. Notice only issued, my lord. Already.
Notices perhaps is yet to be served, or I have not checked the office.
Death certificate of the also council also have annexed my page 21. That. Let it be awaited, my lord. Regarding ultimately my conviction is there. 2 years conviction, my lord. There, my lord.
Death of the council is otherwise not a very valid ground, but well, up to your lordship. If your lordship wants to hear on merit, let us hear on merit.
Merit part of appeal, my lord, revision, my lord.
In which para you have said your counsel?
Para 5, my para 5. As soon as he got information, my lord, immediately he acted upon it, my lord.
Iman din oh no, warrant to issue, you issue for.
No, that is the warrant also issued and case has been filed also because they are not finding him. Labor manuna, police take care.
Your Mr.
I Hazari County.
Then but judgment order 14 passed by Golakhat in tribunal that effort judgment or as affirmative judgment and order date judgment and order of conviction date 14 12 2010 passed by Daniel DPM Golakhat in year case number 875 of 2007 convicting the present accused Academy under 326 by 34 active sentencing him to suffer from RI for treatment and a fine of 10,000 in default anti-fraud. This subject America data and county for that the subject was not for order caused by the judge and it came to know about the same when he when the tried court passed and the way which he came to know from who believe there in the word in the house of it and this council and then he came to know that his engaged counsel has got expired on and it good. But you have not yet about that of this counsel as well as the order passed by the judge. According to the filing date. However, there is an internet section for actions smart be accused effect by the delay of one who wants it one. There's a delay, the huge delay, and it considered for court, despite of this, that is caused by all of it, the effort one monthly by this report. On this record. Okay, this one is disposed of.
Hello.
And the connected revision petition to be accordingly raised.
The other area is also there, my regarding the suspension of sentence.
Let the matter be registered first.
No problem.
Okay. No, please, Lordship, I'm sorry for interrupting, my lord. I am with regard to item number 17, my lord, that was fixed for time being. So, my lord, some instructions are sought for Mr. P. Sharma is appearing for special PT here. So, my lord, let it be fixed on Friday, my lord. Till then, we will get the instructions.
Friday is the holiday.
My lord, on 27th, my lord.
Friday. Thursday is holiday. Friday is okay.
Thursday is holiday.
24th.
You are on item number 17.
17.
That forest.
Not for the other side.
Well,
24. Released on 24.
well,
Lordship is sitting at 2.
Yes, yes.
Lordship, this matter may come up for Lordship may admit this matter, Lordship, because LCR has come, Lordship. This is crossing our affair, Lordship.
Other side.
Okay.
Petitioner side.
Or
What you
after
say
some
in
time.
absence of it can be appeared.
After
Let the petitioner be appear. This will
After
be
some-
listed after 1 week. After sometimes means you want to fix it again for time being. After 1 week. Petitioner. एक मिनट लगेगा. It's after.
Met visual also. Here in this case, Lordship, this is second application is filed for suspension of sentence and grant of bail. But I find, Lordship, that probably this matter should be listed before same bench. That page 52 is the earlier order, Lordship.
52. It will be better, I think.
Lordship. Normally it is listed before same bench.
Without it. It's next
That order about that order may be mentioned, Lordship, in the that rejected by honorable.
Editorial. No, it shouldn't be mentioned. Just appendage it will be appropriate bench.
If you want any date fix, then I can. Otherwise, after 1 week, will be fixed.
Any date may be fixed because I do not know whether next week that bench will be available or not. Therefore, I'm saying that bench is available this week, Lordship.
This week it is available.
Yeah.
But this week,
On Friday, Lordship, 24th.
Friday is a working day.
Yes, 24 is gone.
Okay. This for appropriate day. 24.
Problem.
May it please your lordship, there is a delay of 39 days in filing this appeal, your lordship. I'm convicted under section 448 and 354 of the Indian Penal Code.
39 days.
39 days.
Yes, Mr. Begum. Will be all right? Can it be? I'm not finding your name here. Oh, it's at the independent.
Yes, sir.
Any administrative applicant. So hard. MSA. This is an application. Bring control delay 39 days in filing the tribunal appeal against the June judgment and order if that for the past in connected station case number 15 packet of small big cap 2020 by 12 by the India number India as was used to conflict the accused applicant and section 440 3 months for IPC. We have mentioned your reasons for delay in which para?
Paragraph, Your Lordship. Paragraph 3.
Paragraph 3.
Paragraph 3, Your Lordship.
Basically, due to poor financial condition.
Yes, Your Lordship. You are suffering from jaundice, basically, Your Lordship.
Okay.
I have stated in page 4, Your Lordship.
Submitted that the applicants and applicant was suffering for jaundice for a period of from 10/12 to 23. It was submitted. It covered only on council somehow identified the connected appeal, and in that process there was the delay of certainty in by further subject there is no section for part of and it said could not fight of next MFK it has not delay and the delay of settlement is considering made that the grounds of witness as well and cannot and thereby delay of number by the your petition is disposed of.
I'm deeply aware.
Here, what is the delay?
This is Lordship. Made to the Lordship.
It is delay connotation or what?
Delay connotation, Lordship.
Delay. How? What was the delay?
As per the registry,
Delay,
Lordship, 505 days, Lordship.
50?
5 days. The date of knowledge is, Lordship, 24 March 2023.
Date of?
Date of knowledge.
Date of knowledge.
Yes, sir.
And then you 505 days.
Yes, sir. It was an ex parte order, Lordship, passed by the Family Code number 2, increment, FT Criminal 264 of 2020. The reason has been explained in para 5, Lordship. May I read it? The impugned judgment was pronounced on 1/7/2022, and since the said order was an ex parte order, the same came to the notice of the appellant petitioner on 24 March 2023. That is the date of knowledge when the certified copies of the impugned order dated 1/7/2022 was received by the applicant petitioner. Thereafter, the earlier engaged counsel had filed a criminal appeal petition on 24 March 2023 itself against the said impugned order, but due to some lack of due diligence on the part of the earlier counsel, the matter was remarked as defective, Lordship, as it was filed under incorrect provision of law. And thereafter, the same was again filed by the earlier engaged counsel, who had to withdraw the earlier criminal appeal, that is on 31st 2024, and filed a matrimonial appeal on 2nd February 24. But unfortunately, again after filing the aforesaid mat appeal, the registry informed the earlier engaged counsel that the matter was remarked as defective, as it was again filed under incorrect provision of law, as per the registry of Guwahati High Court. and thereafter the same has been filed as criminal revision, the instant petition, by the present council. Hence the delay, Lord.
Yeah, please, Your Lordship. Lordship, I'm for the respondent, Lordship. Lordship, 2 weeks' time may be given for filing objection, Lordship, regarding the delay, Lordship.
Which is that, are you getting any maintenance at present?
Yes,
We
Lordship,
are
I'm
paying.
getting, but
You are
only
paying.
for
Yes,
only for the child, Lordship, not for me, not for the wife, Lordship.
You want to file any objection here?
Yes, Lordship.
Short date may be given, Lordship.
So, Mr. H.
C. Kumar.
C. Kumar.
Yes. On behalf of Mr. S. Dekar.
Mr. C. Kumar. But you have to,
M. Das.
M. Das. Not what. After
2 weeks.
Obliged, Lordship.
Much obliged.
May it please your lordship. This I is for an application for correction of typographical error appearing in the judgment and order dated 29/9/2023. Your lordship, we have annexed the order. Kindly turn over to page number 22, your lordship. In paragraph 25, line number 5, your lordship. Consequently, the owner insurer, it ought to have been owner oblique insured. And your lordship, in the same paragraph, line number 8, in the event of non-payment by the owner insurer, it ought to have been
Right,
insured.
number 9.
Yes, your lord.
Then application for correction of the correction of inadvertent error during a judgment and order dated 29/9/2023 passed by this court in connection with amnesty appeal number 153 of 2016. It is submitted by Mr. Karta that in the judgment in para 25, in para 25 of the judgment, in fifth line, it is written as owner slash insurer instead of insured, and in the same para, in line number 9, it is again as owner slash insurer in place of that for it paid for correction of typographical error in para number that's up and for the line number 5 and line number 9 of para number 25 which will be the time. Because it 25 para page number 22 to check the all para you begin inverted form and place majority the owner come insurer should be insured again owner come insurer should be that will be read as under with the above observation the highest.
Your lordship, another thing
The line is number 8, the second
No,
one.
no, 9, 9. In para number 25.
25, Your Lordship.
This is line number 8 or 9?
Lordship, I think
I
it's
have the
8.
9, 1. Oh, sorry, 8. Yes, 8. Line number 8. All put line number 8. Okay.
Much okay.
I put the para in but comma.
May I please, Your Lordship? This is an interlocutory application for suspension of sentence. There are 3 applicants. The conviction is for 10 years. So I believe the state will be filing an written objection.
At the apart from this, this has come for the first time.
This has come for the first time.
So, are there any other respondents?
No, Lord. There is only
State
one
is
state.
State. Submitted by
Do not know.
no problem. Harvard extra copy submitted by the state by state by
Sunnah, 12 of Sunnah, detective.
Accordingly, 2 weeks will do.
2 weeks, sir. Can it be on 4th of June?
Lordship, let it be on 7th of June.
7th. This from 7th of June. Wednesday, and applicant state responded by okay, it will be this.
Highly obliged.
Lordship, in item 15, Lordship, I was under an impression it may be called after completion of order matters, Lordship. So may I pray your Lordship may first, after hearing all the order matters, may call.
In fact, we call it for twice, I think.
Lordship,
Call it
I was under
twice
an
in
impression maybe after order matters it will be called, Lordship. So before
Because
hearing,
earlier we
Lordship,
called, then again we waited, and then again it was called for.
Lordship.
Mr. Locker was
It
there.
will take some time. So, Lordship,
After 1 week we have listed it.
Lordship, today is the date fixed before the learned trial court. There is no stay, Lordship. Quashing of the FIR, the petitioner is an advocate, Lordship.
But we are not going to hear the matter now.
Before hearing matters, Lordship, if possible.
No, today is not.
Probably next date is after some few days, na? After few days, next date तो दिन पिछले दिन fixed हो सके. आज तो date बोले यारो.
Today is the date.
Today
so
was
he-
the date,
he
so
is
next date will
there
be-
is
it
no
already
interim.
over. Let us know the next date.
Lordship.
Then we'll give try to give prior to the next day, next topic.
Lordship.
We'll give right.
Lordship.
Just let us know, we are just
Lordship.
okay. Otherwise, we listed it for 1 week.
Lordship.
Because twice it was called for and remain.
In fact, Lordship, I am waiting that your Lordship may finish all the matters, then I start, Lordship.
Okay. Anyway, you just let us know. We'll
Lordship.
May I please your Lordship?
Yes.
First of all, I congratulate your Lordship here.
Thank you, thank you.
Your Lordship, I am before your Lordship. There are 2 petitioners. They have come before this IA. They wanted to be pleaded as a party in this criminal petition. As because the matter is like this, the petitioners' cell deeds has been seized along with the seized other cell deeds which are seized here in this connection of this case. What happened here? The petitioners purchased plot of land by obtaining necessary permission from the authority concerned, and I have already annexed your Lordship the annexure A. Your Lordship may kindly see. These are the permission.
In page number?
Page number 15, your Lordship. Sorry, 12. 12. Page 12 and 15. Oh, sorry, 14. 12 and 14. These are 2 permission from the authority concerned. After obtaining this permission, my cell deeds were registered, and that was done in the year 2010. And after purchasing, I am in possession of this land, and still I am in possession. The only problem what has come, Your Lordship, I could not mutate my name, and when I went to the office to get my deeds, then they informed me that there is some irregularity in the office, and so those deeds has been seized. Your Lordship, kindly see Annexure C, page 15. There was complaint against the deed and registrar. Page 15, Annexure C, that was relating to some deeds in the registered in the year 2006 in different dates bearing number so and so and so. So my deeds are registered in the year 2010. It has no connection with this. And apart from that, the other page 16, Annexure D. Annexure D. That is an FIR. On the basis of that irregularity, an FIR was lodged. And here it is specifically mentioned that I inviting reference to above, I would like to inform that Sri Gajen Patak, the then sub-registrar, has executed large number of sale deeds numbering 754. All these deeds are related to 2006, whereas my deeds are 2006, 10. So illegally my deeds are also seized with this. And now it is 2024, Your Lordship. When I went to the office of registrar and I wanted to get my deeds released, they told me that no, we cannot because the case is registered and the matter is now pending before the High Court. That is in criminal revision before Your Lordship. That is a criminal petition number 213 of 13. So I filed this petition to implead me as a party respondent in this case, in this criminal petition, and then I filed next petition, other one, that is for releasing my deeds. So first I may be impleaded as a party. I have no grievance against petitioner. I am just affected because my deeds are seized, whereas my deeds are nowhere connected. So that is my simple prayer before Lordship. Firstly, I have to be impleaded as a party in this case. He is petitioner, Your Lordship, and I have no grievance against him. That is a different matter. Only my 5 deeds. I have 5 sale deeds, which has been seized, and I have given the specific numbers of those deeds. Similarly, Your Lordship, there was petition filed, and this court has passed an order. This is the order, Your Lordship, may kindly see. Same FIR. And Your Lordship, earlier I also filed one WPC going through this petition. Then I was asked by the court, Reed court, that no, in Reed court we will not entertain this petition. You go into the appropriate court. So I have come and I have annexed that order also.
How can you implicate yourself in the case?
Because I am agreed. I am third party. I am aggrieved. Then how? Then multiplicity of
criminal.
Then multiplicity of I5 prime separate petition. It will multiplicity, Your Lordship. This is the second round I have come because I filed WPC. Your Lordship may kindly see annexure, page 31.
This is this one.
Not this one. Okay. I have annexed the petition. Page 30, annexure I. Page 30. Operative portion, page 31. I came with a read petition. There I was asked that to file appropriate petition as petition be so advised. So appropriately, it is only that I can be implemented here as a party. Other than the multiplicity of petitions will go on. And FIR, I am not challenging. I am challenging only my deeds may be released, nothing else. And that is 2010, Your Lordship.
But by the way, otherwise also you won't get any relief in this case because this criminal petition. No, it's criminal petition. 2013. It is of 2013.
Yes.
Your criminal petition is of 2013.
Yes.
My lord, I have some small prayers, my lord. May it please your lordship and congratulations. My lord, I do not have any grievance against our applications. But the only
obviously you don't have any grievance.
Only thing is that whether technically this is permissible.
No, that's what I'm saying.
My learned
your
friend,
petition is
my learned friend has submitted an order of a coordinated bench of Honorable Justice Debashish Borua, I think.
Yes, Debashish Borua.
Kindly see the order, my lord. The order said that a competent court may be the court of the judicial magistrate. Kindly see the order, my lord. And this is a coordinated bench. Whether my lord would differ.
No. That's what I'm just saying.
My second point is
that This is a petition 482. You're just praying for quashing of the, and with the quashing of the FIR, she has no relation.
Yeah,
So
my-
she is not the accused of
My-
whatever. Nothing is there.
my lord.
Her deed is anyhow. It was seized by seized. I mean, she's not. I mean, most probably she could not get her name
See,
mutated.
yes.
Though it was registered in 2010. That is our
My
only
lord,
budget.
I am trying to I am trying to help her, my lord. She is in problem. I have understood.
Because but
My lord,
here
my lord, my lord, kindly see, in the main criminal petition, there is an order dated 23/5/2022,
23/5.
2022 by Honorable Justice Mr. M.R. Pathak.
The petition is before the court or not? Criminal petition is before the court or not?
Yes, my lord, the petition
Acha,
is,
yes, I have.
yes, my lord. In the last part, my lord, I read the order today. Kindly see the order, my lord. The order reflected that the charge sheet has been filed. Kindly see, my lord. My lord, I have not drafted this petition. I didn't file it, my lord. I was engaged by the petitioner. I do not. I have forgotten how he came to me. From 2015 onwards, I do not have any contact with him. He was a cancer patient at that time. He gave me 3 telephone numbers. I tried, but failed. But I have done to the petition. Prayer is that he challenged the FIR,
Yeah, only FI.
not the charge sheet.
Not the
If the judgment of the Honorable Justice M.R. Bhuya, it is a judgment of the Honorable Court that charge sheet is filed and cognizance is taken under Section 409 of the CRPC by the learned court below. Under the circumstances, my lord, whether this should be kept pending, my lord, I cannot say that this should be dismissed, my lord, but my lord may pass an appropriate order and there is no use of keeping this case, I think, pending, my lord.
No, but you have option. I don't know whether your petition, how your petitioner is instructed you.
Right.
The question is that earlier when you file for quashing of the FIR only.
FIR, my lord.
But here the order speaks that already charge sheet is there.
Filed.
Cognizance has been taken
Again,
under 409.
therefore,
So
I think,
at present,
therefore, I think nothing remains in the petition, my lord, criminal petition.
two things may be there. Either may not be there any remaining, or you can file an additional affidavit or in the form of whatever incorporating your prayer for the quashing of the
My lord,
charge sheet also.
my lord, I
That
thought,
can be
my
done.
lord, my lord, I thought it, but it is very difficult, my lord. I tried my level best.
Who will sign?
Who will sign, my lord? Right. And 2015 onwards, I have not seen him, my lord. Therefore, maybe on
Can
merit,
you take instruction and let us know on the next date? If you want to withdraw it, then definitely it will be withdrawn. Otherwise,
my lord,
there are
my lord,
options.
I cannot withdraw also. Let it be decided on merit, my lord,
What is
because
saying next day?
because what I was asking merit, because since the challenge is only the challenge to the FIR,
That's what, yes.
and charge sheet has already been filed. Therefore, nothing remains in the petition because after the FIR investigation is completed,
That's what I'm saying, that you have the option
my lord.
to incorporate your prayer to an additional affidavit if you want to.
Yes, ma'am.
Otherwise, it's a FIR only,
Yes, my
not
lord.
the charge sheet.
My
So
lord.
definitely you are saying that otherwise there will be no relief because charge sheet is already there. Quashing of FIR will not arise at this
Yes,
point
ma'am.
of time.
Yes, ma'am.
Yes, obviously after the charge sheet, FIR may be quashed, but the question is that at present only for the quashing of FIR only.
Yes, ma'am.
So charge sheet remains there.
Yes, ma'am.
So in that case, you take over and
My
if you
lord.
want to withdraw this, we can.
My lord,
write
for
application.
withdrawal, one instruction is required, my lord.
Definitely one instruction will be required.
Yes.
Otherwise, in the merit too, we have to heard the matter again afresh and everything will be there. It will be exercised because
My
you
lord,
also know that
my lord,
this is a
kindly
request.
give some time, at least the month of May, so that I will find him out.
In the month of May itself or June?
No, June, my lord.
In the
First
month of June.
June, my
So
lord.
your client is still surviving or
That I
instruction
will
also you
ascertain
don't
physically.
have.
I will ascertain physically.
Talk to your client and whatever you see.
By physically, from the affidavit, I will find out the address and I will.
And regarding your thing, it is not.
Your Lordship, I am agree party. Where I will go then?
You
I am agree with this
for the
FIR.
CGM, I think.
Your Lordship, they are not CGM. How can I go? There is no instruction in my case like this.
because I went to registry and all. They are saying that we cannot, because since the matter is pending before High Court, we cannot. So they will not do anything unless the matter is disposed of here. The thing is that, so my only prayer is, let me be a party. I may be implemented. I am agree party. I am agree party. I am affected by this. So let I be party. Then thereafter you also decide the matter.
No, you
as your
cannot be
lordship is-
party. You cannot be a party.
So where will I go? I have no option. WPC was not
The
allowed.
release of your, if anything is there, you have to make, you have file a complaint. You have to be complaint.
Complain against whom I will go? Because I have no complaint. I only want to get my deeds released, nothing else. Regarding FIR, I have no complaint. They will do they will take its own course. I have nothing to say. If there's irregularity, the court will decide. Regarding my only grievance is that my deeds of 2010, this is 2024 going on. Till date, I could not.
For most probably read court before they read court.
I went to read court about your lordship has seen the order. What to do? I prefer read petition only.
Implement will not do it.
Read court is saying no, because this is read court. The criminal case is pending. You before that go to that court. So I have come with this petition.
Criminal case is pending, not against you or not against you are
No,
not involved in
no,
this case.
no.
But the question is only your deed has been ready. So you have to file a complaint. Otherwise, how did this be? And in this case, this particular case, you cannot be a party.
Your lordship, complain against whom? Because they will say the matter is pending before High Court. We cannot do anything. Even magistrate will say like this. Registry will also say that we cannot release, and police will say that we cannot do anything because matter is before High Court. So everything is before your lordship
What
now.
is the main case, the original case, this is the criminal petition is only become, as per his submission, it has become infructuous.
Yes,
No
then,
prayer is there.
then everything goes.
Everything. Then I can list in next week. That is the
Next week, yeah, early. Because my client is suffering a lot.
My lord, for a moment. এটা লিভ লৈ নলয় কিয় কোৰ্টৰ পৰা চিজন কোৰ্টত যাম বুলি পেলাই
কি leave?
দেৱাশিষ বৰুৱাই যেনেকে লিভ দিছে এটা লিভ লৈ লওক তেতিয়াহ'লে আপুনি বাচি গ'ল
কিন্তু এইটো কোড পেন্ডিং থাকিলে ইয়াতে
যদি লিভ দিয়ে দেৱাশিষ বৰুৱাই দিয়াৰ
next when the next it will be listed, we'll do that.
rightly suggested. You can pray for.
Yes.
We can dispose of the matter.
Yes.
With a direction that you can approach the.
Yes, appropriate, like that,
appropriate.
similar, yeah.
Yes,
That
can
will
be
do,
done.
that will do, that will
So
do.
next week, both matters will be listed.
Yes,
in the
yes,
next
so
week.
that
Let
is
him
fine.
take
Yes.
the instruction first.
We both will be protected.
Otherwise, your entire petition will go.
We both will be protected by that.
deeply obligement.
Oh. Please go ahead.
Hey, order to give away.
In month of June, you want?
Yes, my lord.
June which date?
June. First, second, third, any date.
Any date.
Second is Sunday. Third or 4th June? 4th June? এই মাহত কিয় নলয়?
মানে I lost my wife.
Yes, yes.
Nobody is there with me.
Your wife?
Oh.
So sad.
3-6?
3-6? 3-6, right.
Much obliged. 3-6. When?
Whole Kishori. Oh, only.
3-6 will give up.
Deeply obliged. Okay, online.
I have for condonation of delay, my lord, 69 days, my lord.
69 days.
Yes, my lord.
What was the reason why it is? It was
My lord, paragraph 2, my lord.
paragraph?
Paragraph 2, my lord, page 4, my lord. Here is, my lord, two grounds, my lord. One is, my lord, is the poor person, and secondly, my lord, the petitioner under impression that his parents will file the appeal, my lord, by engaging a private advocate, my lord. But, my lord, parents of the petitioner, my lord, applicant, my lord, under impression that the appeal filed through the jail authority, my lord. That's why, my lord.
He is in jail.
Yes, my lord. 10 years.
But there is a provision to jail authority. it is
Yes,
fine.
yes, my lord.
And
Under
now it is-
impression, my lord. Appellant is under impression that his parents will file the appeal through a private engaged counsel, my lord. But, my lord, parents of the applicant is under impression that the appeal will be filed through the jail authority. That was not done, my lord. Ultimately, somehow collected some money, my lord, and I came to ask, my lord. That's why, my lord, 69 days in delay.
This is the first instance, right?
Yes.
Should we pass any order or issue notice at least formality for it because the Informant is there. There's a
Yes,
party.
informant is there.
Like it issue notice first.
Yes.
Not period, and then
Yes,
the next date
yes,
apply.
Step গুলো আপনি এখন দিয়ে দেবেন।
কেন 10 বছর আগে।
Advance an order against it. Let the formality take
Yes.
notice and then
Yes.
cannot fix a date. I think it will be listed
Yes,
after
yes,
2
yes,
weeks.
yes.
After.
After 2 weeks, any date, ma'am?
Date will not serve your purpose. I think date. No.
I'll take it.
You submit.
Yes.
2 weeks will do. I think.
Yes, ma'am. 2 weeks.
Let it be on.
Oh, please.
May I please, Your Lordship. Lordship, connected appeal, there is a delay of 153 days. And
153
days. It has been explained in paragraph number 2 and 3, to Lordship.
This is also same. Most probably, this is related to
Lordship.
354 as well as POXO is there.
Sorry.
So just do the formalities in the other case like other issue notice first.
Yes, sir.
After 2 weeks, it will be tested. Let us see. This after.
May I plead, Your Lordship? This IA is for condonation of delay of 236 days, Your Lordship.
Notice, ma'am.
233 days.
36 days, Your Lordship.
So at this stage, you issue notice.
Notice.
We'll see. Notice. How many? 153 days did it?
236 days.
236
236 days, Your Lordship. The delay is explained in para 5, Your Lordship.
What was the reason?
Actually, I am a resident from Nagaon, but the case was going on in Kamrup district, so there was miscommunication, Your Lordship. So that's why I came to know only in this year only.
Okay, your theory may be genuine. State may not have any such kind of objection also, but do the formality, issue notice first.
Yes,
to the respond number 2 to register daily and eligible profit. We are going to list it in like other 2 methods. We are listing it after 2 weeks. Let us.
Yes, Your Lordship. Deeply obliged.
Please, Your Lordship. The first time listed the appeal, Your Lordship, challenging the order for the Lana Trial Court.
It's a POXO.
POXO, Your Lordship.
Okay, to the formalities, issue notice. To
Lord, Lord. No. Aye.
It's after. To register daily and as usual process to take step 40 weeks. We are listing it after 2 weeks.
Obliged.
Wait, please, Your Lordship. Lordship, my senior is on on other court. Lordship, this is a suo motu petition. On the last occasion, there was an order saying that summons is to be issued to the respondent number 2 or 3 in item number 47. Lordship, may kindly peruse the last order.
Item number 47.
Yes, Lordship. Registry is to take steps, Lordship, which is not yet taken.
So there was an order to verify. The order was on to verify the registry regarding the status of the service.
Lordship, may this made a
Lordship, this is a suo motu petition.
My senior will argue. Your fault.
No, but
You're fine.
office not to go.
You stand here. This is the respondent.
Registry you are already. But okay, then your senior is coming.
Yeah.
But though it is listed for hearing, there was a direction from this court to verify as to whether there was any steps or what is the status of the service on the response number 2. So as per the office note dated 10/5/2024, there is no steps were taken for the response number 2. That is the report of the registry. So that means you have not taken any steps for response number 2.
Lordship, it is to be taken by the registry. This is the sole motor petition of the High Court.
Is to be taken by the registry.
Yes, Lord.
The registry आपको क्यों not to be taken? Is it verify कोई भी रखती है? Verify just it's not good. Okay, for like. Huh? Hmm. Hi. Then the registry had, I mean, put the order, I mean, the note, no fresh steps have been laid by the. So they are to take steps. That order was that the registry is to verify. But they have not, it's as per the note, there no fresh steps have been taken.
Maybe Lordship could make it very specific this time that the registry has to take the step.
Do you have anything to say? Your senior is coming. Let us wait for some time then. He is saying that. Okay, then we are waiting for them. Or you can take instruction from your senior also. Just we are waiting. Because it is in hearing column, but the order is there in that way. So, who is the response number 2? Who is the response number 2?
One is Rahul Pao, Mr. Rahul Pao, in one of the petitions, and in another petition,
one is Rahul
Pao. And in the other petition is Kirod Dole. Lordship may kindly take up the order of 3/1/2023. It would make the case very clear.
Is anything registry verify code to no report on verification by the registry. Simply one report is there that the no trace state is taken. So that is the note of the rate. So we may specify the order and ask, is there any submission from your side? Those two matters are for 2009.
Lordship, in this matter, item number 46, hearing had already completed, Lordship.
Item 40?
Item 46. And 47 also, it's a similar matter against the same person. Lordship, 47 had completed. As such, Lordship may peruse the order of 3/1/2023, where it's specifically written that argument has been submitted for the judicial officer, and it is submitted that argument submitted in criminal revision petition number 323 can be taken up as the argument in criminal revision petition number 347 in the other case, Lordship. However, in that case, in criminal revision petition 347, this respondent number 2 did not appear, because of which it was asked to the registry that steps should be taken on that person.
Otherwise, hearing is completed.
Yes, hearing was taken by a coordinate bench, Lordship.
It can be directed.
Yes,
because there no report from the registry, in fact. It was order was that to verify the status of the server. But instead of taking any step, the registry otherwise the other way. That no steps has been taken. It was the registry to take steps. And verification note is also not there, whether what is the status of the server. Otherwise, as per submission made by the counsel for the respondent, the hearing is already complete.
Lordship, in the order of 3/1/23, it is being directed that registry is directed to issue fresh notice to respondent number 2 by registered post with AD as well as by usual process.
Yes, but that part, the report is otherwise.
Yes. Already there is an order. 3/1/23.
So, okay then? Or you want to submit anything else? Huh?
Steps
Part her?
No, Lordship. Even their part was completed in item number 46, Lordship.
She may not be in a position to say anything.
The order will be same.
Definitely. Because otherwise it was okay, because hearing is also completed, but the order on 3/1 that reflects that for the respondent number 2. That is the main issue. Otherwise, the hearings are also most probably complete.
I will inform.
Because cannot be wait with the other will be appear. Eh? Huh? Common order. You are MS?
N Begum.
You M Begum. N Begum. You are for the respondent.
Yes. 1.
N Begum for 1. You are Miss? S?
S. Dole.
S. Dole for you are for respondent number 1, na?
Yes.
And S. Dole for respondent number 2 on behalf of Mr. K. K. Mohanta?
No, I am for K. K. Mohanta. I am on behalf of Mr. K.
You are on behalf of K. K. Mohanta. And you are?
J. Pai.
J. Pai. On J. Pai. So you are for the respondent. You are for the other side.
She is also for the respondent.
Also, you are also the respondent. Okay. I'll do it for the respondent. As per order dated 3/1/2023 passed by the court in bench, the registry was directed to take fresh steps on respondent number 2, Mr. Thiro Dole, to register both registered post and as usual process, registered AD and as usual process. And it seems that by order dated 21/3/2024 also, this court directed the registry to verify the status of the service in respect of respondent number 2. But the registry has not taken any steps. Rather, from the office notes, it reveals that the registry was awaited for steps on respondent number 2 by the petitioner that complainant. Thus, the registry has not taken any step or nor verified the status of the service in respect of respondent number 2 in pursuant to order dated 3/1/2023 as well as 21/3/2023. Registry authority directed to the need to visit and immediately report scope as cases pending since 2009. As both the cases are pending, it is accordingly it is a 2009 case. Fixed date will not serve the purpose. Let it be after 2 weeks. We are fixing it after 2 weeks, but let us see. No need to worry, no adverse order is there. Okay. He is also representing the respondent.
My pleasure.
Miss Legal Lordship, in this case, I am appearing on behalf of respondent. My senior is argued a matter. He is engaged another court. So kindly
So
pass
Mr.
over.
Kyle is there.
No, he got to be.
Oh, people.
Next week, any date, my lord.
Because waiting for him, it is already 3. So if you can start now, then it may be completed. Otherwise, yes.
It may not be completed. It may not be completed today if I start. Lordship.
But see, the matter is of 2009.
Yes. That's what I am sitting in fact. That's what court. Otherwise, I would have prayed for an adjournment. I am not keeping well. Because of 2009 matter,
yes.
I am sitting here because I feel myself guilty to.
Yes, 2009 matter. So is there any convenient day for both the parties? We can fix because in that case it may be hard, or it can be fixed in a hearing day. So the priority can be given to hear the matter as early.
Itu lagi hearing.
Baru 11 Jun हुआ 11 Jun नो নাকি বন্ধ হয়ে যাবে তো আর তার আপত্তি আছে নাকি
11 June, my lord.
হ্যাঁ
11 is the hearing day, my lord.
Hearing 11 June because of 2009 matter. So just give us that book that it can be taken up because hearing day is
yes.
11th is a hearing day.
Hearing day.
Okay.
Hearing. 11 is hearing day.
Yes. So we are fixing on 11/9, 11/6. Sorry.
11/6.
Mr. Pine. Somehow we managed her. Otherwise, she was so adamant that unless you come, no, she will not take any date from us. Anyway, we passed the order. Item number 9. None appears to fall. Is that her? So, is that her? Nine. None appears to fall. This stuff. Is it?
The Lordship has passed order after 1 week, and
lower court fixes in the month of July, Lordship. So there it will remain July. Yes, Lordship. But even if suppose after 1 week it may or may not reach. That's why I'm saying.
One day
So let it be in the month of June then. Any day. Lordship, then I will mention it, Lordship. No, your Lordship is fixing a date. Just earlier, in your absence, we have passed for 1 week. Lordship. Now we have intimated that it is between month of July. Lordship. But 1 week may not reach. That's what I'm saying. If
Lordship.
it reaches, okay. But even if it's not reached, suppose then we can fix the date in the month of June only. Yes. Who took the dictation? Kim. Item number 17. Na?
15.
15. Item 15.
7 on 15. 5 on 7.
Show her presence on the. Can it be a fixed date on the almost later part of the document in the month? Then we are fixing it on 18/6. More or less. Lord, we are fixing on 18/6, and your presence will be. We will make it. So, I am putting my endeavor, Lordship. He is my classmate of class 11. So, Lord. Oblige.